Yeah, colleagues, kindly note that we'll start around quarter past, ne? Just around quarter past. So. Yeah, I'll advance the reason at that time when we start. I don't want you just to sit idling and not knowing. We'll start in the,
You see, Chair, the problem is that you say we start at quarter past, and then some of us are going to fall into the trap of Minister Nkabani. Yeah, we start chowing in the committee. It's not right. You must at least tell us why.
No. I'll advance the reason at that time. It's fine, my bad. Noted.
Must I shift? Do you guys need me to shift? I think so. Get in your chair. No, I didn't. No. Especially the phone number. The members always ask for their telephone numbers.
Are you the boundary?
Are you the boundary? Yeah.
In which direction you are doing? You think there's a space to send that if you want to?
You was once this side,
Yeah.
now it's there, but it's coming soon.
It's like
Usedoha, we are connected.
he's
possible that is eyeing the other seat that
Excuse me.
is available.
I don't have my tissues. Bye. And then I'm gonna start sneezing. Just be careful, some of these things they actually chow your back. But like what's our real charge actually chowing your back. Just be careful, some of these things. Yes. It is.
Let me call them. Eating by check. Eating by check. Because Nami bang phone
There for 15 years. Remember that this is okay, yes. No, I'm trying to like the want to socialize. I felt that they did when I came to see that. I was surprised when you said 15 years. But this is the message that we have.
It's 5-0 down.
I think the chair is on the market. I mess it on. But they are waiting for the people in chair. That's why she's calling to ask them if they can.
But if you look at the seating,
So maybe I might need to move. If make it easier, because I he'll have to sit next to chair. nami befuneke ngifike ngigqoke yami imedali ye-comrades nami befuneke nangu igqokile nangu that was the most painful part, and it's the highest point of the race. It's the most painful part. Ibuhlungu. I was still charging.
Honorable members, can I draw your attention and colleagues? It's almost 20 minutes after 6. I would want us to start with our meeting. Earlier on that I indicated that we'll start around 15:15 because I had realized that colleagues were still arriving, and I did not want a situation where we start a meeting and people are walking in up and down, so that we protect the decorum of our engagement. Given the nature of this meeting, just to remind colleagues in the portfolio that we are meeting today the 11th of June 2025 as a sequel of a meeting that we would have had on the 3rd of June on a virtual platform regarding the matters which were of public interest and were in the public space relating to the entity that reports an account to us in terms of oversight, road RAF, the Road Accident Fund. We had an opportunity to engage, as you would remember, and it was as a result of that meeting, hence this is a sequel to that meeting, that honorable members felt that it is going to be important that perhaps we engage with the board, a full board. But it was also as a result of that meeting that there was a request that we must also extend the invite for engagement to Mr. Letswalo, who is the CEO of RAF, but who is on suspension in terms of the report that would have received in terms of the meeting we had, the meeting where the board was led by the acting chair and that the auspice of the Deputy Minister, or Deputy Minister Clem. Now, Honorable Deputy Minister, I want to welcome you. I thought it's necessary for record to remind honorable members why we are here. Allow me to welcome you and welcome the chair, the acting DG, and the chair of the board and the entire board present here. Mr. Lzalo, I'm not seeing you properly from here. I'm not sure if you can sit on the, if it's possible. I also take this moment to also welcome you to this engagement, We are aware, DM, that post our engagement, there have been various developments that would have already unfolded. This include, of course, not limited to the fact that the matter we are dealing with is currently now in the courts of the Republic. We have been alerted to that particular fact, and I think honourable members would have picked that from the report that we received in relation to this particular matter. So I don't know of any other that might have evolved, but I know there would have been several developments. But we will give you an opportunity to take us through in terms of what we requested you to take us through on those particular areas. We will allow members to engage with your report. We'll also, to the extent that members would want to engage Mr. Lutswalo on, will allow that particular process if there are specific engagement that honorable members would want to engage Mr. Lutswalo on. I think that colleagues, Mr. Honorable Mabena, Honorable Ghana.
Yes, towards the chairperson. Yeah, here is the challenge with with your statement.
Yeah.
What I've just said now. We've got a board here that suspended the CEO. You extended an invite to the same CEO. In your opening statement, you are saying members must engage with the suspended same CEO. Now, there's never been a precedent in this parliament that such procedure has ever happened. Also, reminded Chair is that this committee has no powers to overturn a decision of a board. We don't have such powers. But what we are doing now, it borders on interference. And it borders on you actually interfering in the operational matters of the entity. And it's something that is wrong, procedurally is flawed. And also equally, if you are saying us as members, we must engage with, or okay, let me start here. You've extended an invite. When you extend the invite, what did the invite say to the employee of RAF that has been suspended? To say, you are coming to the committee on behalf of RAF, or you are coming to the committee in your personal capacity.
On the point of order, Chair.
You are coming to the committee representing the EXCO. Now, if in your letter of invitation it is stated like that,
there's an order here, Chair.
So please. The issue now becomes to say,
wait, Honorable Maben, hold it there. Hold it, Honorable Blossom. Wait, I'm going to give all of you an opportunity. What I would not want is for you, honorable members, to invite people here as a result of your own meeting and start differing here. If you feel that you want an in-committee, you must propose that we must have an in-committee now, because the chair does not decide or did not decide on who to invite. So I must clarify that. Wait, plus. I must clarify that. So I want Honorable Mabena to finish. Honorable Ghana will come in. You will come in. Or all honorable members will come in. But if you want, all of you, you are raising hand to engage with what Honorable Mabena is saying, then the best thing is that to request honorable colleagues to accuse themselves, and we call for an in-committee, we discuss, so that you do not subject our visitors to a discussion which is not theirs. Because the discussion, by the way, in the first place of calling this meeting, in the fashion that we called it, is not a chair's decision. That is why I was very careful to indicate that this is sequel. No blood. Honorable Kobe. I'm sorry to call you by name, but Honorable Kobe, Honorable Bloss, we don't operate like. I don't know what is in this rough matter that makes us to lose the decorum, because we never had a problem in this committee. Yeah, so no, don't address me. Let's do this. I think you are all interested. DM, I'm very sorry to find myself in this type of a situation and yourselves in this type of a situation. I'm going to request that you recuse us for a while so that I deal with this particular matter with the committee, because it's like now the committee has an afterthought of their own discussions. No. Let's have an in-committee. We are not going to have a discussion in front of our guests about our own issues. And it's fine. We'll deal with that in our own committee. Honorable DM, on that order. No, don't do that. Colleagues, thanks very much. I think we're going to start with the meeting. I perhaps must DM apologize to you and the team for having delayed you, and also to the suspended CEO for having delayed all of you guys for the housekeeping matters that we needed to deal with. It is not out of our own making, it is out of the developments in your own entity that we find ourselves having to go up and down. I think that must be understood. DM, we invited you, like I said, as a sequel to the discussion that we would have had. Yeah. No, but it's you who's disturbing us. Why do you want to transfer it to Mabena? Because you're having a red caucus there. No.
I don't know what's wrong with Honorable Blosser today. It's like there's a bit of excitement.
Yeah, and I'm going to suggest, if you continue that way, I'm going to suggest that Blosser sit where you are seated and you sit where Blosser is seated.
I think very progressive, Chair.
Yeah, but nonetheless, colleagues, at least we are one. We clarified each other. There's certain things that we needed to clarify each other on. We are one. We are proper. We are going to allow you, DM, to take us through in terms of what we would have asked. We are fully aware that there are certain matters, like I indicated, which are in court, which we may not be able to express them properly. Yes, Honorable Mabena.
Thank you very much, Chairperson. In what you are saying now, that the committee has agreed we are one, we just want to register the dissent of the TA, that we don't agree with the issue that is happening now, in terms of having an acting CEO of the entity with a suspended CEO, with the board that suspended that CEO. So we just want to register that the TA is not in support of
no, thanks very much.
But will engage with the board and the acting CEO.
No, thanks very much. I think that is recorded, colleagues. There is that particular dissent. If there is anyone who wants to make that dissent, let's quickly deal with it now, so that we do not shock each other in the process.
Chair, I don't understand why you are allowing it, because the board had taken a resolution. Now to speak to the cameras and tell your bosses that you are disagreeing, it's a collective decision we've done.
No, it's fine.
Those issues.
Thanks
you don't
very
need to
much.
report. Can't tell cameras those things. It's done. Leave it.
Honorable Bloss, I don't know what these cameras doing to you and Honorable Mabena today. I really don't understand. Whatever commitments colleagues would have made, wherever you have made them, please, can we run a meeting now? Honorable DM, but before that, I'm going to request in our part, Valerie, that you read the apologies that we have, and obviously DM will also take us through the apologies. From there, DM, I don't know, you lay a background, and from there, whoever has to present in your part will present. Thanks very much.
Good evening, members and the Road Accident Fund. Apologies were received from the Minister and from the from Parliament, from Ms. Machawu and Dr. Hunsinger, from the Road Accident Fund Board, Advocate Njeza and Mr. Sallow.
Is there any other member who wants to raise any apology that we do not know? If it's not there, let's proceed. DM, over to you.
Thank you very much, Chairperson, Honourable Chair, the honourable members of the Portfolio Committee. The Road Accident Fund and ourselves are here in response to an invitation by the committee following the meeting we held virtually last week. Chair, the invitation had indicated that the meeting would be going on until 8:30. I am scheduled to attend the disaster management meeting this evening, starting at 8:30 because of what is going on in the country. So in the event that I do step out, it would be to ensure that the team we have now asked to stand in for us because of the delay here would arise out of that. Secondly, Chairperson, is to indicate to you that the Road Accident Fund has put a disclaimer in its presentation about how matters need to be handled in light of the fact that yesterday I was advised that the suspended CEO had served papers on the Road Accident Fund and that the Road Accident Fund had to file its affidavits today, for the matter is set to sit on the 17th of June 2025. After consultation and discussions, we still felt it prudent to honor the invitation by the committee in order for it to exercise its parliamentary obligations. It is therefore, Chair, my belief that you will assert, for the purposes of engagement, the Powers, Privileges and Immunities Act, for the purposes of this engagement, that this portfolio committee meeting will perform its functions, understanding that the matter is now in court for the purposes of a competent court to make a determination on the material facts of this matter. And so I think, Chair, it would have been helpful at the start of this meeting, and because there's a Zulu saying, I will not complete, Odindlebe is something. And we have heard.
What is that saying?
I can't complete it.
Oh.
Yeah, so will. I think it would be helpful for you, Chair, to guide on how you want to handle this meeting, because you are saddled with a situation wherein the board of the entity has taken a decision to suspend its CEO and appoint an acting CEO, and post that the matter is now in court. So we would want the committee to give us parameters on the rules of engagement in terms of this portfolio committee meeting. Secondly, Chair, it's to indicate to yourselves, or thirdly, that I had a full day meeting with the board and executives of the Road Accident Fund yesterday, as committed in the correspondence I sent to the board at the advent of this matter, and as also communicated to the portfolio committee when we met on the virtual platform last week. The acting director general and I, who's here, are compiling a report in order for us to explore the next phase of this engagement, with a view to ensure that the entity is stable and that the entity is able to fulfill its responsibilities. We will subject ourselves, Chair, to this process, as is the constitutional injunction of the committee to perform its functions. The board, which is present here, will take you through the sequence of events of the matters currently at hand. My final point, Chair, is to indicate that the matter we are dealing with, amongst others, because I think I need to give that qualification, is currently a subject of two committees in this parliament. The Committee on Public Accounts and the Portfolio Committee on Transport. It remains my fervent outlook and humble request, Chair, that Parliament finds each other and itself for the purposes of coherence and reporting and accountability. We are saddled with the situation that SCOPA has got its own timelines, and I'm pretty certain this committee will also have its own timelines. There is responses which were due to SCOPA, and I've requested an extension because of the latest developments, and that deadline has now been extended to the 20th of June, as for us to be able to submit the necessary information. I conclude, Chair, by saying in the final analysis, the situation at REF is not good. and is cause for concern on a number of material fronts, including but not limited to the situation around the suspension of the CEO. I do not think that it is a light matter, and I do not think that it is a matter to be handled willy-nilly because of the material consequences it has for the organization. It does require us to tread with a particular caution, is not to exacerbate the situation further in the wrong direction, because this suspension, amongst others, comes at a time where there are a number of difficulties which are there. Lastly, is to indicate that, as the board will share, the genesis of this matter being here today, from the understanding of the ministry, is as follows. One, the Standing Committee on Public Accounts was briefed by the SIU on the basis of a preliminary report of an investigation into matters within the ecosystem of the SIU. SCOPA then requested, after that briefing, that the Road Accident Fund come to Parliament to engage on the basis of that meeting. Amongst others, it brought to bear a toing and froing of communication on the basis of what I consider to have been a wrong decision on the part of the board to say that they would not come to Parliament. I wrote to the board. They engaged as a board with the committee and with the SIU to clarify their issues. It remained the position of the ministry that whatever issues that the Road Accident Fund had were to be ventilated in that committee meeting as opposed to correspondence. It is now common cause, as established last week in the meeting that you had, that sequence and series of events led to letters by the now suspended CEO to the Standing Committee on Public Accounts, and an indication that he would not be attending. Subsequently, of course, that meeting took place in Parliament, wherein issues were raised when whatever issues may have been of ref were explained in correspondence, which the board will actually speak to. The special leave which was granted or given to the CEO was rescinded by the board for reasons that they will explain, and then a precautionary suspension was effected. So as far as we are concerned, that is where we are with the matter. I am not privy to the court papers, and I'm not privy to the responses of the Road Accident Fund to that court action. Suffice it to say that I have requested the SIU to brief myself on the nature and circumstance and the extent to which the investigation has gone on, and where it is, or its current status is at this point in time. This information harvesting process I'm engaged in, Chair, is ultimately for the purposes of ensuring that the right and correct decisions about the future and strategic direction of REF are taken. And I say that on the basis that this is not a light and easy matter. So I thought I should give the background in terms of what we know and in terms of what we understand as the board exercised its own responsibilities as per the prescripts of the law is concerned. I do want to conclude by expressing a concern, Chairperson, to say, to indicate that I do not think it is prudent for us to play speculation in the public domain, as this matter has done. I would want us to engage on the basis of facts. And I intend, Chairperson, on writing to the Speaker of the National Assembly on utterances of members of the House outside Parliament on this matter, which have sought, as far as I'm concerned, to dangerously seek to advance a narrative which is outside the facts and without the protection of the powers and privileges extended to members of Parliament. Because it's the rules of this House which must guide our engagement. So I've been concerned by that, and I intend on raising it with the Speaker and yourself, and I think the Chairperson of SCOPA is another committee that is dealing with this matter. Chair, the board has prepared a presentation which I believe has been circulated to yourselves, and would now request that I hand over to the Chairperson of the board to actually lead the presentation with her team. The acting CEO is here, and executives and board members are present. Suffice the apologies that have been read. If there are any others, we will engage correctly with those. And lastly, Chair, to indicate that I will not be drawn into a public spat on a serious and sensitive matter of this nature, which has got a material consequence for the organization and the exercise and discharge of its responsibilities. Thank you very much. Chair, over to you.
No, maybe before the chair comes in, one is to respond to one that you said you'll be stepping out. I think we'll allow you to do that as long as the acting DG is here, and together with the board, then they'll hold the TAF in your absence. I'm not sure whether by the time you finish will not be done, but I think I strongly believe will be done. Or in whatever process you want to do, if it's going in and out, you are allowed in that. Secondly, that in terms of how the meeting must run, merits that you think will compromise your matter that you are dealing with somewhere else, you can indicate that on this matter we feel that we can't, even if there's a question, if you feel that this question is problematic, you may indicate that. Same goes to Mr. Lutswalo. If members ask you questions that you feel that this one is going to compromise what I'm dealing with, you are free to indicate that. I don't think overall the other advice that you actually raise is that we'll be engaging with the Standing Committee on Public Accounts. I did get a brief in terms of various reports that I would have received from the chair, in his capacity as the chair, from chair to chair. I'm going through those particular reports, but I think at a particular time we'll have a joint engagement with them so that we move from the same wavelength. But it is important for this portfolio that it has all the information so that we don't engage with the other committee with a standing committee, for instance. When you are an oversight committee, the standing committee has more information than yourself. It means you are actually sleeping on duty. So that is why this type of engagement, as we prepare for that type of a shared engagement, is important for us. So we'll deal with that. I seriously note your concerns relating to members who speak and things that are perhaps outside the powers and privileges, or things that are outside the scope of our engagement. I'll wait for that brief as you write to the speaker, and also if I will have you'll have the generosity of also sharing with the chair of the portfolio. We'll await that. So we'll proceed in that manner so that we move as speedily as possible. You take us through the report. Members have went through the report to a great extent, so you can just be summative and go through it. From there, I'll just allow members to ask you questions and engage with you on areas that, like I indicated, that you feel you'll be compromised. You'll indicate, and we'll take it from there. From there, they'll also ask certain questions that they may want to ask to Mr. Letswalo, and then we'll take it from there, and then we'll close the meeting. I hope it works
No,
for you.
Chair, that is very much in order. Just my step out will be to ensure that our team has joined the meeting of the disaster management. As you know, we are saddled with the tragedy of having already lost 49 lives in the Eastern Cape, and the situation continues to be adverse, and road infrastructure, of course, is key and material in that regard. So thank you very much, Chair. I think the chairperson of the board...
On that note, may we then observe a moment of silence in honor of those who passed away through this tragedy. May their soul rest in peace. Thanks very much. Sure.
Much, Chair. I think the chairperson of the board has heeded you or heard your guidance, and I will now hand over to the board. Thank you, Chair.
If you could quickly introduce Usu, because yeah.
Chair, I assume the within Yazana because you've also visited Ref. Chair, my name.
Yeah, unless honorable members are comfortable. Or as members speak, they'll introduce themselves so that we save time. Yeah.
Yeah.
No, Chair, but let's quickly introduce. I think it's proper. Yeah, don't take.
All right. Chair, thank you very much. My name is Mkuda Watlangwa, the Deputy Minister of Transport.
Good evening, Honorable Chair and members. My name is Lorraine Francois. I'm the Chair of the Board.
Good evening, Chair and Honourable Members of Parliament. My name is Dr. Nomonde Mabuya Mulwele. I'm the Deputy Chair of the Board. Thank you.
Evening, Chair and Honourable Members. Dr. Pamela Pongega-Matebula, Board Member.
Good evening, Honourable Chair of Portfolio Committee and members of Portfolio Committee. My name is Moses Nyama. I'm the Chair of the Audit Committee. Thank you.
Good evening, Chairperson of the committee and honourable members. Spiwe Blose, the board member.
Any relationship? It matters.
Good evening, Chairperson and the Honourable Committee members. My name is Dr. Pulile Dladla, and I am the Chairperson of the OPSIT Committee. Thank you.
Doctor, you may want to unpack what OPSIT is.
OPSIT is Operations and Information Technology Committee.
Of the board.
Of the board of RAF.
You had confused my members, man. Thanks for that intervention, dear, because I see members are licking their lips.
Good evening, Chair and honorable members. My name is Kwenako Mapi, and I'm a member of the board.
Good evening, Honorable Chair, honorable members. My name is Bongiwe Khumalo, and I am a board member at the RAF.
Good evening, Chair and honorable members. I am Radikwena Pora, the Chief Internal Audit Officer at RAF.
Good evening, Chair and honorable members. My name is Bernice Potgieter. I'm the CFO of RAF.
Good evening, Chair and board members and all committee members. My name is Advocate Piladi Moahi. I'm the acting head of legal at the Road Accident Fund.
Good evening, Chair, honorable members. My name is Mampe Khumalo, and I'm not the head of legal. I don't have an LLB, but I'm the Chief Governance Officer of the Road Accident Fund. Thank you.
Good evening, Chair and honorable members. My name is Patuchedzo Kwareni. I'm the acting CEO.
Good evening, Chair and honorable members. My name is Tulan Chavalala. I'm a board member.
Evening, honorable Chair, honorable members. My name is Mukiti Penani. I'm the board secretariat. Thank you, Chair.
No, Chairperson, I think we are very much in your hands. Mdula Stul, over to you.
Thank you very much, Honorable Chair of PCOTS and members again, our Honorable Deputy Minister of Transport, our Honorable DG, as well as Honorable members of SCOPA that are in attendance, as well as all the other members that are in the room and the members of public. Let me just observe protocols for anybody else that I did not include, and the members of the board and the RAF executives. Chair, I think the DM has opened up appropriately in terms of why we're here, and the fact that the RAF is always committed to account in terms of how we run the organization called the Road Accident Fund. And we respect the powers of the two committees of Parliament that we account to, which is the PCOT and SCOPA. We understand that Rule 227 of the National Assembly actually empowers these committees to exercise oversight over the work that we're doing within the entity. But I'd like to start with the fact that relating to the matter of the suspended CEO, I've been guided in terms of common law principle that proper administration of justice should not be prejudiced, especially when it comes to a matter that is already in court. And I'm saying this all further with the fact that we have the suspended CEO of the RAF in attendance to this meeting. So I just believe that if, in fact, I've been told not to answer any questions or present any facts relating to this matter, because it will actually compromise the RAF case as well as the board case that is currently in court. So what I'll do, Chair, because in terms of making sure that we give you the sequence of events, and the Minister, Deputy Minister has done that already. What I'll do, I will just emphasize the key decisions that the board took around this matter. Just for the record, I'm also cognizant of the fact that on the 3rd of June, 2025, the RAF board actually attended a PCOT invite, and the deputy chairperson that was representing me on that day, I'm aware that she took the committee through the sequence of events up until that particular day, which was the 3rd of June. And so I will basically confirm the key decisions and the dates, and then up to where we are today. And then what we'll do, I will allow the acting CEO, Mr. Lukarani, to take us through all the other matters. But in terms of all the matters relating to the current case that is in court, I will not go beyond the sequence of events and the key dates, because then I'll be failing in my fiduciary duties in protecting the best interest of the RAF in this regard. However, I would like to assure the committee that once the matter is out of court, I mean, the DM is giving you the dates that the matter is set to be heard on the 17th of June. I think it's about next week, but we commit that the RAF board will come back and account further once the matter is out of court. And I'm emphasizing the fact that the deputy chair gave the sequence of events at a time when the matter was still an internal matter within the organization. So there were no restrictions at that point in time. But now today we're sitting, with the different circumstances that now that the matter is in court. But let me not waste too much of your time. Let me just confirm the key dates and that basically started this whole matter up to where we are today. The first decision of the board in this regard was taken on the 27th of May, 2025. And we all, I think it's on record, that the sequence of events and the issues that took place started with the SIU matter that we were supposed to go and present on the 28th of May before the SCOPA committee. And because of some issues of defiance, the board took a resolution after considering the matter before them to ensure that they are not prejudiced in terms of them coming to actually account before a very critical parliamentary committee on the matters that are affecting the RAF, because obviously we are its board. So that decision was taken in consideration of those matters that were before them at the time. And we believe that that was the appropriate decision at the time because it was not a preconceived decision. We were dealing with a crisis that was before the board, and the board had to act to deal with that crisis and also make sure that it discharges its duty to come and account before a parliamentary committee, which is very critical in this country. So the first decision was to place the CEO on special leave. That was the 27th of May. That was following a board decision. And then on the 2nd of June, after taking legal advice, I think it's very important that the board came back and reflected and looked at the magnitude of the conduct at the time, the misconduct, if in fact, to be precise. And we took legal advice and we, excuse me, then the board took another resolution. Two resolutions actually, Chair. The first resolution was to withdraw the special leave and then replace it with a full suspension. That was on the 2nd of June, 2025. And then I think 3 days later, on the 6th of June, the board received a notice of motion of basically the CEO raising matters to dispute the suspension in court. That was on the 6th of June. And the board held a special meeting and considered that motion and took another resolution to defend the matter. So currently the matter is in court. Today we were busy. In fact, in terms of that decision, the chair of the board is actually charged with the responsibility to depose of the answering affidavit in terms of dealing with the defense of this case. And that's why our legal team made it very clear that and I can't answer any questions beyond this or get into too much detail on the matter because it will compromise the case of the RAF as well as the board. So, Chair, let me end up here and I will allow Mr. Lukwareni to continue with the rest of the presentation. It has been shared with the committee. Thank you.
Thanks, Chair, and good evening again. Mukiti, if you can just go to, we have been asked to answer specific questions over and above the issues I think that the Chair raised, and I will just run through those quite quickly, Chair, because the first issue was around vacancies in the fund and some of the reasons why they have not been filled. So just at a high level, the vacancy rate at the RAF is around 17%. That is across the organization. We have been implementing a new organizational structure that was approved on the 31st of March, 2022. And then obviously the filling of positions was also impacted by the by a halt to the Section 189 process that was taking place following engagements with organized labor. But the next slide will just Mukiti, will just show you that at the high level, in terms of the ex-core positions, we have 3 vacancies in the main, and the vacancies, of course, that had where we have had serious difficulties in filling the positions include that of the Chief Claims Officer. We have gone to the market a couple of times in this position, but we now have to go back to the market, but we have now appointed someone to act in that position. The Chief Corporate Support Officer also suffered a similar fate in terms of multiple attempts in the market. But I think we are more hopeful with this one, because I think it's also at an advanced stage, because I think the assessments of candidates have already been done, and we are ready to interview. The Chief Investment Officer position had also been put on hold. The main reason I think the board took at the time was to first process the investment policy to guide the process going forward. I think those are the main positions. The rest of the positions in the EXCO are filled. In terms of the second question, that mainly related to the leases of the offices of the RAF for the past 10 years. I think that was so I'll just talk to the overall cost without necessarily going into the details of the offices over the past 10 years. I think if you go to the next slide, Mukiti, that's the one that has the totals. Yeah, that's the 854 million over the past 10 years, of course, across all the offices, and these amounts also include included in the also include water and electricity, operational cost, security, and on all aspects. But that's over 10 years. You can see all the buildings there, the specific offices. I think we try to be as transparent as possible. Next. I think we also asked to put addendums of when these decisions were taken to the board and when the board approved extensions and the original contract. We've put all those details there. Next, Mukiti. We were also asked to update on the status of the panel of legal service providers used by RAF and the reasons for the reported increase in summary judgments against the RAF. Just at a high level, we have provided the committee with high level with the attorney allocation criteria in terms of how the panel is structured, that all these attorney firms are structured according to specific categories, whether it be public law, personal injury, labor and employment law, and obviously just to also emphasize that as part of the appointment process, the 2 firms that were mainly raised, I think, are arising from the engagement with SCOPA, also find themselves having been appointed to participate in, I think it's 3 of these categories. There were other issues that we wanted to also bring to the attention of the committee around how the panel operates. There are so there are 12 firms, for example, that have that can be briefed because of conflict of interest, and in this regard, conflict of interest mainly relates to them still doing plaintiff work, rough plaintiff work, which makes it difficult for them to then represent RAF on those similar matters. Obviously, we have a process where there is disclosure around conflict of interest. There's periodic checks that are done to confirm if the conflict has been resolved with those specific firms. There is also an issue around similar and successful matters as a principle of allocation criteria, where matters are related, they're given to the same firm who have had, for example, one firm issuing 180 contempt court applications against the CEO, for example. It is obviously prudent to make sure that it's only one firm that is dealing with those, because so that those issues can be managed optimally. So there are situations where a firm has previously dealt with a matter successfully, then they're given similar matters, because obviously in instances where matters are urgent, you do not want to start your briefing process from scratch in terms of making sure that firms having to understand the mandate of the RAF and all of that. Then you obviously have continuation of legacy matters from a previous panel. You have matters that were carried over that needed to continue. Next. Yeah, I think we have those main issues where it's whether it's conflict of interest. There are also instances where there's just no agreement in terms of, or alignment in terms of the legal strategy. Whether it's, then there are those that have got issues of non-adherence with timelines, and we have had instances of firms that were not available due to agency. And I think we also, in the next slide, Mukiti, I think this is just the list around some of the firms that are on the panel where there are conflict of interest issues. So there was an expectation that there is a process that needed to be followed in order to rectify that. Next. And then we have specific firms where they were, specific issues that they had difficulty with. You had one firm, for example, refusing an instruction involving an illegal immigrant because they believed that illegal immigrants are entitled to compensation. So that on its own, it becomes a difficulty from an legal strategy alignment perspective. So we've tried to also articulate those. Next. Yeah, we've also provided transparency around volumes per attorney, and also indicating context around some of the volumes that may look, particularly on Mpoyane Lidwaba, for example, where we had those 180 contempt court applications which had to be allocated for purposes of practicality. And thanks. Then we also attempt to provide the list of critical matters where some of these firms are dealing with, and this obviously are matters that go on for a longer period, and I think that's what we have tried to show in the list. Next one. And then we also demonstrate the successful cases per attorney, so that there is also an appreciation that they've also succeeded in significant matters that have gone over a period of time, which also has cost implications in favor of the fund. So the committee will be able to look at that. And then we also obviously then show the litigation and legal cost as was provided to SCOPA. And then here we also just provide a bit of context that the significant portion of the payout is to disbursements to counsel fees and not necessarily to the attorney fees. Specifically, you'll see there, for example, in the case of Malachi in 2023, of the 9.3 the attorney fees would have been 9.3 million, and then the council disbursements would just been just over 30 million. So I think the trend continues across the periods. We also reflect on the issue around default judgments, and we, in explaining default judgments, we thought we should explain it in context by bringing to the attention of the committee that for example, if you see in the financial year 23-24, the default judgments with 3% of the claims that were settled by or paid out by the RAF. Now maybe I must pause here a bit to explain that the main key driver for the strategy of the RAF post the 2025 strategy is essentially to move towards settlements by agreement. Because ultimately, the only way to avoid litigation costs is to increase the settlement by agreements. Now, the legacy problem of the RAF is that the number that you see, that is settlement by agreement, for example, that is 80% in 23-24. That number in the period between 2015 to 2020, that number was hovering in the 50% range. Now, that was the main issue. Then it meant that the balance of that was being handled in court. And that obviously shot up the litigation cost. Now, the approach, the new approach was to then say, how do we move away from a litigious operating model, focus on settlement by agreements? And then, of course, that is clear that has succeeded, but it certainly is not enough in terms of averting some of the default judgments that we see, and I think we'll explain how default judgments materialize. But I think, like we were saying, even in the engagement we had with the Deputy Minister yesterday, that it is the correct strategic trajectory to focus the fund on settlement by agreement. In other words, we must put all the resources we have to focus on that. We should not be tempted to throw out the baby with the bathwater because there is 3% default judgments in the settlements, and I think that's the point that we're making. So I think if you go to the next slide, we then explain that although default judgments are not desirable, we must properly characterize them. As we indicate that even in a default court, the judge is only allowed to grant default judgment after hearing evidence. The purpose of hearing evidence is to enable the judge to reach a decision that a valid claim exists in law. Now, we also provide examples where a default court judge would have dismissed the matter because a valid claim did not exist, or examples where a default court judge would have granted a lower amount to what has been paid for by the plaintiff. Now, of course, we also provide a case where the full court held that a court cannot act as a mere rubber stamp for the parties. Now, the problem we've obviously been having is that there is obviously a characterization of default judgment as some expenses or expenditure in vain, which in fact is not correct, in that this is still claims expenditure. But as I've said, it is a process that we must work towards, and in terms of optimizing our operating model. If you go to the next slide, Mkiti. So we're saying that payments are made pursuant to a default judgment are therefore or not expenses or payments made in vain. And we had this engagement with the AGSA in 22-23 financial year, where they also looked at whether they could fit the fruitless and wasteful expenditure parameters, and it clearly did not fit. Now, additionally, there is a process that court orders that there is a process internally that they are then taken through. An instances where there are problems, there is a rescission application that can be made in cases where there are fraudulent or overstated court orders that are grossly overstated. But I think the principle should be whatever we do, the process must be to continue on the trajectory to move to capacitate towards settlement, because we should litigate by exception. And I think that should be the principle that we should move towards. Now, of course, we must continuously enhance the capacity of state attorneys to ensure that there is optimal performance. There are currently initiatives that are on the go to recruit administrative staff, paralegals, and admin secretaries in particular to support the state attorneys. We are optimizing our block settlements. This is the key initiative behind the settlement by agreements that you have seen, the percentage that has increased there. Now, we are also participating in a key project that we believe will be a key game changer in terms of court-annexed mediation. It's a process that we started at the beginning of our strategy on our own, but it didn't go very far. But now that the judiciary is involved, we believe it can be a game changer that will also use to drive settlements. You'll see that some of the root causes are mainly around court directives, because in the main, default judgments are mainly a Gauteng problem. You'll see that in the numbers. I think there have been challenges that we have been having around some of the court directives that have come out of that particular court, and we have a coordinated approach that we have now with the judiciary, particularly as a result of this particular mediation project. Now, we also have a specific challenge, Mukiti, around huge challenges to some of the administrative decisions that we have made. Whether it is the decision of minimum requirements for lodgement of claim, that decision has been challenged to an extent that those whose claims are rejected go and issue summonses, which then obviously create a situation where there is an upshoot in some of these summonses. We know about the non-payment of past medical expenses. These are the key drivers of even these contempt applications that you have seen, because it is these decisions that every strategic change that has been made to attempt, the minimum requirements is its main objective and purpose is simply to ensure that we receive claims we can do something about at a basic level, and that has been challenged across the board. Now, obviously, we can't overemphasize the need for finalization of legislative reforms, because all what we have been doing is to work within the current legislative framework, which I think has got serious limitations that I think have been traversed before this committee. Next, I think this will also dovetail with some of the issues I was talking about now in terms of the status of some of the claims. Let's go, Mkiti. Now, the first part is on the outstanding personal claims and direct claims versus the legally represented claims. But first, the outstanding personal claims. The trajectory of personal claims, you will see that pre-2015 to 2020, that trajectory has always been upwards. The personal claims that were coming into the fund were simply out of control, which essentially created a huge backlog that at the beginning of 2020 we needed to deal with. Now, you will see that it is only from 2023 that you begin to see this come down. In fact, from the beginning of the strategy, we started to halt the rate of increase, but it has started coming down. And even the unaudited number of 2025 is still showing a decrease. Now, why has this happened? Amongst others, the main root cause, as we've indicated before, has been that the outstanding claims is a factor of the number of claims that you register and those that you are able to finalize and settle. Now, in the circumstance where we were receiving and lodging claims that we could, with insufficient information, that we could do very little about, all it did was obviously then escalate and inflate the liability and then increase this outstanding personal claim number. And of course, you'll see that the direct claims also have gone down because we simply, the reality is that the current legislative framework is not designed for direct claims. Because as we have explained here before many a times, that in order to get your claim, you essentially have to sue the fund. And the only way to sue the fund is you need to be a lawyer. And that's the difficulty. So the expectation that there will be direct claims coming in droves is not realistic in the current legislative framework. I think that that must be clear. Now, the other, if anything, you don't hear anything in this presentation, this next table is quite important because it is also at the core of what we were trying to derive in this strategy, that of the claims expenditure that we receive, or rather the fuel levy amount that we receive, the significant portion must go to the claimant. Now, if you look at where we are now, in 2024-25, that's the unaudited number, we are at 88.6%. That is compensation percentage as a percentage of total claims expenditure. It means that the cost to expend the compensation is only about, or what we call administrative costs, are just around 11%. That's the number that was at the core of the problem of the RAF. Now, to then reduce it from where it was in the past to 11%, then you need to understand that there is a shrink of the administrative cost, of course, that was going to various third parties in the past, and I think that is at the core of the problem. But it is the correct strategic trajectory that we need to follow, and it aligns with settlement by agreements. Because the moment you settle through agreements outside of courts, that's the number you're going to see. And it is that we must continue to drive. If there are challenges in the operating model, I am yet to find a strategic choice without inherent risks in implementation. And the correct question always to ask should be, whether the strategic trajectory that you're on is the correct one. Are you focusing on the right goal in the context of the fund? And I must also emphasize, Chair, that the committee is well aware that the RAF has not received any fuel levy increase over the past 4 years. Now, the last commission of inquiry, pre-democratic era, the Melamed Commission warned at that time that there is going to come a time where there is going to be an irresistible opposition to any increase in fuel levy. And he says, when that time comes, what must happen is we must do exactly what happened with when the insurance industry collapsed. In other words, you need to restructure the benefits structure of the fund. The problem of the RAF is not the funding, it's not on the revenue side, it's on the benefit structure. And that is what the legislative review needs to assist. And I think the initiatives, the cost-saving initiatives of the past 3 years inevitably will have short legs, and I think can never be sustainable until we have a lasting solution around the legislative intervention. Now, I think the other issue is the settlement time, turnaround time. We said before, I think when we came before this committee, that there used to be a specific target in the strategy of the RAF to target to settle claims in 1,440 days in an APP. Now, as a target. Now, that then explained, so it meant that when people achieved in 1,300 days, you could easily get bonuses and all of that. Now, that inevitably then created the perfect storm that we had to inherit.
Sorry, just hold it there. I'm seeing a hand there.
Yeah.
Chair, thanks very much. Can I ask, I know the ref had prepared for this presentation. And I know that they've said they presented some of this information to SCOPA. We never requested this information. And I thought that the chair of the board said after the 17th, they'll come back they'll come to share with us. You see, because we can't discuss this item in this way. And I think that the deputy minister also said they're looking at other things, so they will discuss properly those issues that are there. So I think my view is that we need to park that part of the discussion and have a meeting of because this was a special meeting to discuss specific issues, which I think that the board chair touched at the beginning before we moved to the second part. So this part of the discussion or of the presentation, I think that I suggest, Chair, concretely that we park it. We park it till the 17th, because I think it must be discussed in a proper way, not in the way that we're doing.
Thanks very much.
So that's my suggestion, Chair.
Yeah, I think we're going to allow colleagues to finalize because in that order.
Yeah, let me conclude. I think I was at the tail end.
Be intimidated. Just
no. I was at the tail end. So as I was indicating that that was the target at the time. We, over the past 3 years, since the introduction of the RAF Form 1, I mean the minimum requirements, we have seen that improve to around just over 300 days, although we still, in our APP, put our heads on the block in terms of making sure that we settle claims within 120 days. That remains our target. That remains even in the 25-26 APP. And the final question, I think, around this area that we were asked was around the cost of the claims that are settled currently in our books, and we say that that is the RNYP. That's what we call the RNYP in the RAF. and that amount is just over 10 billion. Again, it's another a number that has been on the increase over the past past years. I think you could see that it only began to drop when since the implementation of the strategy, and had nothing changed, that number would have been 51 billion at the currently. Next. Yeah, I think that's it. The copy of the advert. I think the chair of the board missed to talk to it. Thanks.
Thank you, Acting CEO. Chair, the last matter is still part of the court papers, so that initial disclaimer applies. We will come back once the matter has been heard in court accordingly. Thank you very much.
Thank you very much. Thank you very much.
There's a song, Chair. This is my story, this is my song. Indaba yethi phela lapho.
Diabulela. Now, colleagues, yeah. I know all honorable members are going to speak. I need to make sure that we operate in a fruitful manner in terms of efficiency. But just before that, I need to caution members. You may be having specific interest on a particular issue, but that does not mean other members are not interested in a particular issue. I think that's important to underscore, because when others are asking, because it might happen, you must not be impatient. We must allow everyone to ask what he feels comfortable with, in line with the framework of questions that would have sent to the entity. I'm going to take hands, colleagues. I'm taking one set. Let it go. Yeah. So now that you are all going to speak, we are going to speak in this manner. Honorable Kubeka, you will start. You'll be followed by Honorable Mabena. Honorable Mabena will be followed by Honorable Skwambane. Honorable Skwambane will be followed by Honorable Kobe. Honorable Kobe will be followed by Honorable Matuna. This will be the first set. The first set. You are going to be allowed 3 minutes to speak, ask questions. From there, on that particular set, I'll allow you a follow-up when you're answered, and then we'll move to the next set. We're going to start on that manner. Honorable Kubeka. Honorable Malmacha, if you can stand in. It from where you are seated.
Thank you. Thank you, Chair, and greetings to the board, greetings to the RAF team, greetings to the Deputy Minister, greetings, honorable members. I think before I ask any question, when it comes to the issue of RAF as a whole, I did at some stage ask that I was asking the SIU specifically, because I know that bulk of what we are here for stems from what comes from that preliminary investigation into RAF by SIU. The question was, if the SIU comes to Parliament with an incomplete investigation, do they not fear that the media will run with incorrect narratives about individuals and about the entity? And the answer I got was that the people will have a right of reply. Now, given the amount of media attention that the issue of RAF has gotten, there's a lot that has been said based on what the SIU report had mentioned. And the people who are actually involved in that SIU report have not had a right of reply. And we find ourselves in this situation right now where the media has run with their own narrative about what happened. And dare I say, bulk of what has been said, we have not had a response from the people or the person or the main character in the story. Now, I think I asked this before, and the Deputy Minister did answer it. But from where we stand, I think I'm still of the opinion that it seems as though the CEO was being silenced by a way of how this thing happened. Because before he came to speak in Scopa, and just for those who do not know, I sit in Scopa as well. So a day before the CEO comes here, he's told no, he's put on special leave. And when the board realized that they made a mistake in saying that no, the CEO must go on special leave, they go and rescind the decision and they make another one where they put him on suspension. And when you ask the reason for that suspension, you're told no, he refused to appear before the board or before Scope or before Parliament. Now, when you go and you look at how this thing happened, it looks too opportunistic, Chair, that you will say no, he did not want to come before Parliament. When we know the acting CEO came here and said to us that no, I flew down with the CEO is here in Cape Town. He was ready to come and speak to us, and then he was told at night, I think it was around 11, that no, you are no longer coming, you've been put on special leave. Now, for the board to then rescind on that decision and then put him on suspension now, or precautionary suspension, or whatever they will call it now with those fancy words, they're putting him on that precautionary suspension after they had said to him that he mustn't come to Parliament. I think, Chair, the question then would be, could they clarify that sequence of events? Because right now, it seems to us, or from where we stand, that the board put him on special leave and said he mustn't come. And then they go and suspend him for not coming. So I would just like to know, what is the rationale, what is the idea, or what is the sequence of events in that situation? And then, given the presentation that we just got now, I have to ask, Chair, the question, another question on the Discovery Health versus RAF case. How much was Discovery claiming from RAF? And I see that one of the successful cases was Discovery Health versus RAF. I see that the lawyers that were involved there was Malachi and Co. and Ponyana Letwaba. Now, Chair, if that is the case, the next question then is this not the main driver behind the fight over Ponyana Letwaba attorneys and Malachi and Co. to say that no, they've received bulk of the work that comes from RAF, given that they challenged Discovery and won? That is a question to RAF now. Chair, I would like to recall, and I'd like to remind everyone here, that when we last sat, it was said that the Deputy Minister and the board said the CEO is not guilty of anything. And then we asked, why is he put on forced special leave? And we didn't get the question, so I'll ask that again. If the Deputy Minister and the board said in this House that the CEO is not guilty of anything, why was he put on special leave? Why was he then later or subsequently basically fired? Suspended, sorry. The next question will be...
I may have been out, but I think you are bordering on exhausting your time now.
Okay, thank you, Chair.
And I think from now I'm going to put my timer on now.
Okay, Chair.
Sure.
And then you just put me off now, Chair. The building that and one of the buildings that is the it's on that presentation. I wanted to ask, who do these buildings belong to? I don't remember what slide it was. Oh, that slide there. That slide. I see there's the Johannesburg building. Who does that building belong to? The head office in Johannesburg. Who does that building belong to? Thank you, Chair.
Thank you very much. You are followed by Maben.
Thank you very much.
I'm starting the time.
Thank you very much. Okay, I think according to your report on slide 9, you do admit that the entity has a higher vacancy rate of 17%. And I think that issue for me is a bit of a challenge because it speaks to an entity that has a bit of instability in terms of leadership. So there is also a number of C-suite positions, and a total number of them is about 10 of them. Well, the entire complement of the C-suite is about 10, but a significant number of that is vacant. Now, the issue now is that, firstly, we have a situation where the head of claims operations is vacant. And as a result, effectively, that role is performed by the CEO. Now, the other issue that we have with that is that the chief claims officer and the head of claims operations, the CEO assumed those functions of the chief claims officer, given that the claims officer, or given that the head of claims position is also vacant. But also, again, Mpho Manyasha, the head of office, or maybe the chief of staff of the CEO, she also currently serves as the acting chief corporate support officer, through which she oversees the corporate communications and people management. In effect, therefore, meaning that she also acts as road accident funds head of human resources. Now here, maybe are the questions that I want to ask. Number one, what job level is the head of the office of the CEO position? And given that, as I said earlier, that Manyasha was permitted to take up the position as an acting chief support officer, that's the issue we're dealing with. And then also, what changes in vacancies and acting positions in the road accident funds organization structure have occurred since August 2024? And when the latest annual report was signed off, and when was the latest annual report signed off? And then maybe on the same issue around the issues of vacancies, how did the board sign off the Road Accidents Funds 2023-2024 annual report, given the clearing concerns as presented in the organizational structure alone? Do you, as the board, have the necessary foresight in terms of RAF and identify, do you potentially see any governance concerns and issues within RAF, given some of these issues that we're raising here? Another issue is, Chair?
You're out of time.
Okay, let me conclude. What is the function of the Chief Investment Officer, given that the Road Accident Fund is not really meant to have, or does not really have assets to manage? But also, if you go back up on the structure, there is a head of asset management within the organizational structure as well. But then, as I said, the issue of the 17% of the vacancy rate is concerned in slide 9, but also the subsequent issues that I've raised are regarding that issue.
Thank you. Time up. Who's following? Squamba.
Thank you, Chair. I don't know because I wanted to have a one-on-one session with the person that I wanted to ask a question, but I can see that it's actually taking.
Who do you want to ask?
I wanted to ask the
No,
suspended.
that will be done later. For now, we're asking the board. If you have no question against the board, it's fine.
No, okay, I don't have any question for the board, but just to make some remarks, to say we welcome the RAF 101 lecture that was given here today. It was a sort of we are in a lecture hall. But what needs to be known and what the public must know.
It was like I'm in a lecture hall.
Yes.
Not we.
I'm not alone here.
Not us.
Yeah. So, but by the way, Chair, you know, lying is a problem. When you lie, it's a problem. And in front of me here, I see old people here, older than me enough, that I can say when I look at them, they are at the age of my parents, and I don't expect old people to lie. Why do I say that?
On a point
Chair?
of order, Chairperson.
Hold it there.
The rules of the House, Chair, apply in a committee.
Yes.
We are a sub. The committee is a subcommittee of the House.
I wanted.
And I think that the board must be protected. We are here to account.
I wanted to come there. Look, Squamba, I know you may be in this committee for the first time. We subscribe to the rules of the House to the latter here.
But it's not the first time I am attending committee meetings.
No, I'm saying, yeah, we subscribe to the rules of the latter. So the decorum is important. For sure, you would have heard I use this word several times. If this...
Okay, they're not lying, they're misleading.
Yeah, if you feel misled, it's fine, but don't label them as lying.
They're misleading.
Okay, it's
Yes.
fine.
So I'm using the correct word that the deputy minister may be comfortable of. They are misleading.
So are you done?
No, I'm not done. There's one thing that I want to say to the...
Chairperson, on a point of order.
No, but my time is being eaten by the deputy minister.
Controlled by me. So you have no right to speak
I don't
about... your time is protected by me.
Okay.
Yeah. If you can switch off, Minister.
Chairperson, when we invoke the rules of the House, it's not a matter of comfort.
Yeah.
We are invoking the rules of the House, and all I'm asking for is that we be engaged in a manner which is conducive for engagement. My outlook then we can do that.
No, thanks, on DM. I think I've dealt with that particular part already.
Yeah. Thank you, Chair. And I don't know why the deputy minister is going back there because we're...
No. Proceed, my chief.
Yes. So, Chair, why am I saying the board is misleading? They appeared before SCOP in the absence of the suspended CEO. And in that very same meeting that they've attended, the reasons given there for the suspended CEO not to attend the meeting was that you was actually not aware of the meeting here as a suspended CEO. So now the now acting CEO in that meeting says the suspended CEO is actually around Cape Town, ready to attend the meeting, but was not informed of the meeting, by the way, right? Okay, we leave those things now. They go and suspend him immediately after that meeting that he did not attend. And the reason provided that is that they suspended him on the reason that he did not appear before SCOP. And now today here, the chair of the board says to us, the reason they took a decision of suspending the CEO, it is based on the legal advice that they got from their legal team, which is not in detail or what is actually detailed in the legal advice. But one can equally tell to say there's a level of misleading or a deliberate way of wanting to mislead the public with reasons behind suspending the CEO. But when that time comes of asking the CEO questions, I think I will have enough time to ask the CEO questions. But if also you will be not able to respond to the questions that I will put before him, based on the fact that the matter now is before court, you will be able to indicate that I won't be able to answer to this question because the matter is on court. But what I want to register is that we must stop misleading the public with serious issues that the public may want to have interest on them. Because here we are having people before us who continuously come with big reports like that. And while serious issues that brought us, my understanding of this meeting is that we wanted to understand why the CEO was not part of the meeting and at the later stage was what? Was suspended. And we have been given a slides here of a lecture hall. Thank you, Chair. I think I will come to ask the CEO some questions. Thank you.
Colleagues, maybe I must clarify this matter also. We did not ask them to present only on the suspension, so that I must not create impression also that we are the ones who created a problem. You would have asked a set of questions that they actually had to respond to, including the leases, the vacancy rates and all that. That is why, by the way, I allowed them to present the report, and when Honorable Montana was intervening, I would have then said, let them complete, because they did not create the report out of their own imagination. It was out of your own directive. So I needed to clarify that. Honorable Kobe.
Thank you very much, Chair. Chair, I'd just like us maybe to start with the slide where they speak about the vacancies that are open. Right there, Chair. I'd just specifically, so the Chief Claims Officer is vacant. Just like for them to clarify for us, how long has this been vacant for? Who has been acting in that regard? Because we do know that the CEO has been acting in that regard. Who's playing now oversight in terms of risk? We have a head of risk in here, right? Do we have a head of risk or a head of internal audit who's able to keep checks and balances? Because you can't now play a person who approves the claims, but you still also need to play oversight. It can't work. You can't be a player and referee. So I need to know in terms of risk management within REF. I think that question should be directed to Mr. Nyama, if I'm not mistaken. Is that the head of internal audit? This gentleman in front of me. Do I have your name incorrect, sir?
Yeah. Through you, Chair, if I may.
What would I clarify? The name?
The CIOA. It's Ndata Radikwen. It's just behind me on my left as well.
Thank you.
Apologies, Chair. Apologies, colleagues. But yes, Chair, I'd just like to know in terms of that, that from 2022, who's been playing that role and who has then been playing oversight. And to the board, for me, I think this just shows a lot of irresponsibility. But I'll ask another one. The Chief Investment Officer, Chair, it looks as though it's on hold. According to reports, is the position not currently, held by Mr. Sifutle Mudiba? And if so, what were the vetting processes to vet him as an individual who should be responsible for such a portfolio, given how he has left from his position in the city of Johannesburg as a councillor? Just like to know if any vetting processes in that regard have taken place on the end of the board. Chair, I'd also like to ask about in terms of the deviations. I know they've given us a list of law firms. They've given us Malachi and Mboyana and Ledwaba who have received a disproportionately huge amount of work from REF. I'd just like to know with regards to the information that they have given us, Is it in fact accurate? And also, can they tell us about Gertnel attorneys and if any deviations have been enacted from their end when they then required services from Gertnel attorneys?
Thank you for sticking to time. Honorable Maduna, you are last on the set.
No, thanks.
I hope
Chair.
you'll do likewise.
Hey, this 3 minutes is small, eh? No, thanks, Chair. I will try as well and be as precise as possible. Chair, no, we welcome the presentation. Being is that it may, I think as a remark, because we also happen to sit on Scopa, I must just say that I'm if in line with what I think one of the speakers would have spoken about it. I'm interested to see the local opinion that would have advised the board to put the CEO on the basis that they were bringing forth to enforce the special leave, because I've never really saw something like that, especially with the regulation that speaks into the issues of special leave. But being as it may, I can say that they took the lecture that we provided at Scopa and they subsequently, according to the reasons that they were providing, because if you're providing the reasons that they were providing, then it means you must suspend someone, you must precautionarily suspend someone, of which I believe it's what they ended up at the end of the day doing. But being as it may, Chair, I just have a few questions. One, on the issue of office accommodations to RAV, especially the ones in Joburg, because I think in the public domain there's a lot of interest around these issues, and we need to make sure that there's a clarity around them. One, I just want to check. Before the RAV moved to those offices, where was RAV? Which offices they were using? What were you paying for those offices? In the current offices that you moved to that are said to be owned by the pension fund. Two. There was an allegation that initially, I think it's there in the public domain, that RAF would have not taken the company that would have been recommended by bid adjudication. I just wanted to know, is this true? If so, was that company cheaper than the one that was taken? Because I believe that it's for a good cause when you are renting offices from the government employees pension fund. Two, I want to check on the issue in line with the previous speaker. I want to check in the issue of the chief claims. Was board aware, because I believe that the person have been not there for about a year or so. Were you aware of that the person is not there? And I believe that did you give approval to the CEO acting as a chief claims officer? And as well, what was the view of risk management and internal audit? Because I know there's a process of risk management that must be done annually, which is what internal audit use when they develop a risk-based plan. So that's my other question. On the grab dispute with HE, I just want to check, because I believe, was this a board decision? I believe it was, but I just want to ask, because we need to put things into perspective now. Was this a board decision? And who was the legal firm? And that would have given the advice that HE can be, you can take HE to court on those bases. And is that the same legal firm that represented you on the case? Perhaps let's just look into
conclude.
Yeah, Chair. As I conclude, Chair, I think, Chair, my worry as I conclude, which is, I think it's around the last question. Did board know that RAF did not have? Was it aware of the information that there is no head of legal under Silapa? And then, lastly, as I conclude, Chair, I think in the issue of the suspension of the CEO, I say that in many slides it's sub judice. But I must say that it really worries me. Because in the public domain, there are many things that the CEO was suspended because there was a podcast, I think, where he spoke about the conflict of interest that involved judges. And I think Raf has been doing a great work, especially with the issue of Discover. I saw that they won the case. So I must say that I'm really worried because there's a perception that is being created.
Thank you very much. Not that I'm protecting judges, but your time is up. First set of questions, DM, if you could.
No, thank you very much, Chair. I think largely the questions are for the board, for the board to respond. Suffice it to say, Chairperson, that at that SCOPA meeting, we, for the purposes of clarity, the SIU has not briefed the ministry on its matters. And that meeting is scheduled to take place next week, Wednesday. And we will get an update on the part of the SIU. Honorable Gupega makes the comment around the suspended CEO not being guilty of anything. That remains the understanding of the ministry, that the special leave, amongst others, was to give space and time for the suspended CEO now, was not suspended at that point, to engage with the processes of the SIU. So I reiterate what I said in that committee meeting, in this committee's meeting, and in the statement that we released as a department after having been informed of this decision. The only expectation that we have is that if there's an SIU process underway, all affected parties or all those who will have to present information or present themselves to the SIU should do so in order to ensure that the processes run their logical course. And then lastly is to indicate that rightly or wrongly, this issue is not without precedence in this parliament generally, in that and in the SIU operations as I understand them, that a preliminary report of the SIU has been used before and can be used for the purposes of onward use by other bodies, including but not limited to law enforcement agencies, to then investigate on the basis of that report. So it's not without precedence, but I'm not privy, Chair, to the content of the SIU report and when or briefing, but at the point at which I receive that report and briefing next week, Wednesday, I'll be in a better and stronger position to actually know what is going on. And so I think that because Honorable Gupega, having been in the SCOPA meeting, I think he also then places another issue on the table, and for me to clarify that as far as the ministry is concerned, there is no basis to the claim that the suspended CEO was being suspended on the basis that, one, I was informed by the chairperson of the portfolio of the standing committee that he is in receipt of a letter from the suspended CEO that he would drafted by his legal representatives, and I'm sure you can share records that he would not be attending the committee meeting. It is, amongst others, one of the reasons why, one, I said the board must attend the meeting, because I do not agree with the position that the board took, and I stated that up front. It was wrong for the board to take a decision to say that they would not be attending SCOPA. But they subsequently rescinded that decision to attend SCOPA. And I'm advised that the suspended CEO, through his legal representatives, had said that he would not be attending. So it is up to the board then to give you the full and nuanced details of the processes of that meeting. And I think, Chair, for the purposes of the record on the, because SCOPA had a deadline upon which it had wanted to actually get a report and a presentation, is that I wrote to the board on the 23rd of May, wherein I said that REF is hereby directed to honor the SCOPA invitation to appear before the committee on Wednesday, 28 May 2025, and in that meeting ventilate the matters that you raise in your letter. And the response I received from the chairperson of the board is that, having interacted with SCOPA and the SIU, the board had resolved that they would now be attending the SCOPA meeting. So I stand by the response, therefore, for the purposes of clarity that I gave at the SCOPA meeting, that I do not believe that the CEO was being silenced if Parliament was in receipt of a letter saying that he would not be attending the meeting. And then it's to also then indicate that my understanding was that this decision was taken in a board meeting which commenced at 8:30 or thereabout in the morning on the day upon which the special leave was granted. And therefore, I do not believe, Chairperson, that we can be associated with silencing, because the decisions would have been communicated through the day. So in the event that there's any ambiguity, the basis upon which I made the claim and comment I made in SCOPA is that one, that's the information that we had. And up to now, it has not been revised, and therefore I still stand by what I said. Thank you.
You can pass the bite. You can pass the bite.
Thank you very much, honorable members. I will deal with questions that were directed to the board. The rest of the questions, which are mostly operational, the acting CEO will deal with. I think the first one is about the chief claims officer position. Oh, okay. No, the first one is about the vacancy rate. What was the board's position when they signed the previous annual report? Let me be on record to state that the board has been, on a continuous basis, raising this matter of the high vacancy rate, particularly the critical positions, the executive and senior manager positions. And we even directed the subcommittee of the board, REMCO, to actually prioritize this matter. We were told that most of the key positions are in progress, and we are aware of that, because the chair of REMCO was part of that. At one stage, I was also part of the panels that started dealing with the recruitment of executives. But because of the nature of the RAF, there's a whole lot of risks around people, attracting people, critical people or experienced people into the RAF. So there were a lot of challenges in attracting the people who were competent to fill these positions. But the other problem that was given to us was the Section 189 dispute with the unions. If we recall correctly, in the past, as part of the 5-year turnaround strategy, the RAF implemented, it reviewed its organizational structure and then started implementing when it was approved. Then there was a dispute between the labor in terms of some of the conditions affecting their members in the implementation of that structure, emanating from Section 189. So the implementation of the structure was actually placed on hold pending those disputes being handled in the various labor fronts, as well as just to try and resolve that matter. So those were the main reasons why those issues were not fast-tracked. But the board was on record to actually say that we need to get them out of the way. So currently, we've given them at least 4 months to ensure that all the critical executive vacancies will be filled. So we should come back and be able to give some responses, because we said in positions that have already been out in terms of the recruitment process and we failed to actually attract the right candidates, we need to go out and headhunt, and that would fast track the process. So hopefully that will fast track the process. And then the issue around the chief claims officer position, again, these risks that are raised by the honorable member were raised. We are on record of raising those issues around segregation of duty, as well as the fact that if you are a CEO and you are acting in a position that reports to you, so if there's a dispute on issue, who actually presides in terms of clearing that matter? Those questions were asked. And the reasons we were given to us by the CEO was, first of all, that he was the only person who had the correct competence because of the RAF being a very complex organization. Remember that that position requires somebody with a legal mind as well as a medical experience. So the answers we used to receive in the boardroom was that currently he's the only one doing that, but we were aware that there were, processes, that were ongoing in terms of filling that position, but the challenge is that they couldn't get the right candidate to actually deal with it. But currently, the position is now temporarily being occupied by one of the regional managers, because you have people within the regions who actually process claims in their managerial functions, and they should basically be able to assume this position, because also you need to ensure that you expose other managers, in acting in senior positions. So right now we have one of the regional managers caretaking that position. Hopefully then they will fast track the filling of vacancies, again using the possibility of going out there in the market and start headhunting. I think the last question around the board. Or did we approve of him acting in that vacancy? No, it was never put before us to approve that. Like I've just said, that we had concerns around that. I think the chief internal auditor will also talk to us, because we were given assurances that there are checks and balances in ensuring that, nothing, gets irregular is actually happening in that environment, and that the auditors, the processes gets audited on an annual basis. And then lastly, regarding I think the question was answered in terms of the board decision around the AXA matter. I think it has been deliberated on a number of occasions, but the actual legal firm that was appointed, I think that became, the ambit, fell within the ambit of the CEO and the executives. However, the board is currently going to a process of reviewing looking at other options that will actually assist it to get out of, court in a very technical manner, because the issue around this is that the technical dispute remains in terms of the fact that we don't have a relevant social benefit standard in which the organization can use in accounting for its claims liability as well as the associated expenditure. So the board is going through that, but we were given 21 days to actually do a risk assessment as well as an impact analysis if we basically go out of court and find other amicable ways to resolve the problem. So we should be able to come back and give direction after 21 days, because the ministry, and we appreciate that, is willing to work with us in terms of progressive decision making, in terms of coming out of that once we've done a proper risk assessment and impact analysis, because there's going to be very serious impacts on the business of RAF, because there are other legal implications around that decision. I think, Chair, I've answered all the questions relating to the board. I'll allow Mr. Lucaroni to answer the rest.
Thanks, Chair. I think the Chair also answered a few questions around vacancies. I think I'll just pick those that I think needs more emphasis. I think the first one, Honorable Kubeka asks about the impact of the discovery versus the RAF matter. It's a huge matter for the RAF, for the sustainability of the RAF, not only from a medical claims perspective, Honorable Kubeka, but because I think this is the judgment that affirmed that the RAF is not an insurer. So it's very significant in that manner. Although we have not quantified the specific claims that might ensue from discovery specifically. This is bigger than discovery, that there are also other medical aids that is the avalanche that will be opened around medical aid schemes that will also come and seek this reimbursement. So this is a huge judgment for the sustainability of the RAF going forward. So I think that context is important. Of course, one cannot really comment further around whether that then amounts to the victimization or whatever thereof around the firms that you have indicated in question. But it's a huge matter for the RAF. In terms of the Johannesburg building, indeed, it's owned by Moana, as indicated there, which is essentially a GPF owned building, and I think that's how the lease agreement was signed. It's with in that manner. I think that's clear. The other issues related to, I think there are other questions, I think, from Honorable Mabena that were also I think addressed by the chair. As we have indicated, there are only 3 in the main vacant positions at the EXCO level, and I think we must add that on the chief claims officer, there was a real challenge in that space that resulted in the whole EXCO going into the regions to intervene to an extent that the CEO saw it fit to take full responsibility for that position because of the risks that emanated. It was a crisis that was there at the time because of the issues that had to be dealt with at the time, and I think it was always meant to be a temporary intervention because, as we have indicated, the position, there was a lot of work done to try and fill that position that which attempts failed. And of course, we can confirm that there is someone who's acting in that position at the moment. Yeah, I'll talk to it. Now, the other questions, I think, from I think Honorable Kobe also speaks about the issues of the acting of the chief claims officer. I think I've spoken to that. The CIO position and the vettings that is done. I think we have explained this issue around background screening that is done, which was also done even in this case. Reference checks were obtained even from the city of Johannesburg. So vetting is more of a comprehensive process, of course, that takes place where we all subsequently submitted our vetting forms to the State Security Agency, which are still being processed even at this point in time. Now, of course, yeah, we don't brief Gert Nel, attorneys. I know Gert Nel is sitting behind your honorable self. He's a plaintiff attorney. Of course, he does plaintiff work, and he's one of the firms that get the. I think it's one of the top 2 firms. I think we presented in the past, in terms of the payments that get dispersed from the fund, but not as a corporate member of the panel. Now, I think the questions from Honorable Maduna around the issues of the Johannesburg lease, I think I'll ask the CFO to speak to that in terms of the specifics. I think, yeah, Bernice.
Apologies, Chair. If the acting CEO can complete his responses and inform the committee, because I just feel like transparency and divulging all information helps. What is the status of Mr. Mutiba at REF? Because you speak of background checks, can we please just say everything?
DM, thanks for that intervention. You're going to have to be helpful, and you are not going to have to expect your senior to intervene for you to answer questions. That's clear, right? Now, you can't be, you can't apply austerity measures to answers. You're going to have to be as open as it can be possible, so that we do not have a lot of follow-ups in terms of questions. So where you have been asked a question, please, as the DM is saying, just flow and answer the questions as you understood it to be asked, not to want to be, economic with answers. Sure.
No, thanks for the clarity. Like I said, I understood it to be about this security screening, but the subsequent events around the CIO is that he has been placed on suspension as per the also resolution of the board. I think he's currently on suspension.
With effect from?
With effect from yesterday.
Yeah, you see.
Listen,
yeah.
You see, my apologies, Chair. Can we put things in their context? At a SCOPA meeting, SCOPA advised the board of REF and the executives that it was in receipt of a letter from the city of Johannesburg indicating that Mr. Mutiba had resigned on the eve of the conclusion of a disciplinary process. But the information and the letter which came from Mr. Mutiba's letters said other things. Now, I do not understand why we would want to skirt over that matter, because it's substantive to the issues which are giving this follow-up meeting. And Chair, I want to say this to yourselves. It's the last time I'm going to intervene. But I hope this gives you a glimpse of what we are dealing with. You can't be speaking about vetting in your response and place it as substantively as that, but don't add the latest developments in their context that you are in risk, unless the board went and did something different on the basis of that suspension.
Yeah.
So this is, colleagues, the extent to which the problems at REF are. So I'm asking, Chair, that they explain to you so that you don't come back now when something else arises with what's the status of this. Just put it out there. It's not a secret. It's an issue of governance. It's an issue of accountability.
No, DM, it's good that it is coming from yourself, that you are picking what is happening. Acting CEO, what you're doing is wrong. And it borders on being secretive to a committee of parliament. And I don't think we're taking that in kind. And I think it will be for the last time, not only to you, but also to your colleagues. We're not here to play. It's about just after 9 now. And we're not going to be sitting here listening to you, bluffing to us, telling us things not in context, when you actually know what is the context. I ask you, what is that context that you need to give, because the DM has intervened? You still, even in the eyes of the DM, still want to hide other things. And I'm seeing Honorable Kobe still continuously raising a hand from there. I plead with you, please answer the question so that we don't have to take follow-ups. You still want to sweep certain things under the carpet. Why are you doing that? Don't answer that why. Just proceed and give answers.
Yeah, Chair, thanks. My apologies, Chair, if I may come across as...
You are exhausting your daily limits of apologies.
Yeah, as I've indicated that in the matter of the CIO, indeed a board resolution was taken where and pronounced at the portfolio committee. And I think in the meeting yesterday, I did indicate that that particular decision.
Announced to which portfolio?
I'm saying the last portfolio committee. I think the board, when the board presented, they indicated that one of the decisions that were taken was that of the suspension of the CIO, acting CIO. And I indicated again in the meeting that we had with the DM yesterday that I could not just, without applying my mind, because I needed to be the one that signs the suspension letter of the CIO. I needed to apply myself, and after having applied myself, I eventually signed the suspension letter of the CIO, acting CIO. So I think that is...
Hold it there. What do you mean? You want to tell me that what you are saying is that the board pronounced suspension to us when you have not signed the letter? Is that what you are saying?
Correct.
DM?
Chairperson, I would want to believe that the governance shortfalls in RAF are coming to bear, because the issue around the CIO has been a subject of discussion in those COPA meetings. And then my understanding, and the board is here, was they received a response from the City of Johannesburg on this matter. And as I said, we had a meeting yesterday. And up until yesterday, a board decision had not been implemented that the board had pronounced on, insofar as this individual is concerned. So I think, Chair, it is for the board to give you the sequence of events around it, but I would imagine that it's central to accounting to the committee, unless maybe ebuncaneni bami ngibona kafishane. But we are here because there's a suspension that is a subject of discussion. Following that, there is another suspension of the Chief Investment Officer. I would imagine that any response is supposed to be very frank and forthright about that. So that is, if I ultimately, Chair, just my misgiving. Can I ask the board?
I want to come there
to explain its
maybe
due process.
let me ask this in a particular context. The acting chair of the board was there. You are the one who pronounced this issue of the suspension. The chair of the board, obviously, you apologize, so we accepted your apology. Would then imagine that she was acting on your behalf. So the two of you can assist us here. Because this borders on whether we must continue to listen to you tonight, or we must agree that you must go home and pronounce on you. Because if you can come and lie to us literally, and it's the DM who must then, we don't do that, Kwamba, please. And you have the audacity to come, even want to sweep issues under the floor to the extent that you want the DM to be the one intervening. It speaks to your failure in terms of fiduciary duties. Now tell me here, according to your understanding, when does a suspension take effect to a person?
Chair, thank you so much. You are correct. We had a board meeting. It was on the 2nd of June. And we had a whole lot of legal advice that followed specifically on that day. One of the decisions that were taken was the suspension of the CIO. And mainly because we had full evidence of why we needed to suspend him. If I can mention that.
Deputy Chair, I don't want you to give background. I think we're enough with your background.
Maybe the answer is the 3rd of June. On the 2nd of June, we made that decision, and essentially, it doesn't lie within the board. In terms of delegation, that matter goes straight to him as the acting CIO to effect, the acting CEO to effect the decision. So even if we've made the decision, the delegation to implement does not lie with the board. It lies with the acting CEO.
So you said with us, told us in confidence, and if we were to go to the public, said that the CIO is suspended, when actually he is not, is it he or she?
It's a he. It's a he.
When he is not suspended.
Chair, the board made the decision and communicated that decision to the acting CEO. Please understand that the board cannot effect it. It needs to give it back to the acting CEO. And I mean, on the day when we made that, we made him aware of that. So we just can't sign his letter. Delegation lies with him.
Can you answer me here, ma'am?
Yes.
When you came before us,
we had already communicated that.
Can I ask you, can you stop interfering with me when I ask you questions? You are going to have to be respectful here. We are not playing here. When you came before us that you have suspended the CIO, did you have the copy of the letter of suspension?
Chair, I must just verify that. Yes, I do know that we had already given him
I'm saying, did you have the copy of suspension from the CEO? The acting CEO suspending the CIO?
The copy of the letter was issued after we've had the resolution. That letter was also given him. It was forwarded to him so that he could sign. So that letter was available.
I'm saying, did you have a signed copy that Donald Slamlela is suspended?
I can't sign it. It must be signed by him.
Who says you must sign the letter? Do you listen to what I'm asking? I'm asking you. Did you have the copy signed by the delegated authority in this regard?
Okay. No,
can you not disrupt when I ask, ma'am? Okay. Can you switch that mic? Can you learn to be respectful, please? I'm asking you. You are sitting in a committee of parliament in a meeting that is viewed by the people of South Africa, you tell the people of South Africa that you, as the deputy chair of the board, acting obviously on behalf of the chair and your board, you are communicating to us that you have suspended the CIO. When you do not have a proof that that decision has been effected, what is your take on that?
Chair, I take it that the signed letter, I didn't have it in front of me. That is correct.
So you would agree that you misled us?
Chair, if it's seen as a mislead, I want to apologize. That was not the intention.
Seen by who? Do you
Okay,
agree that
Chair,
you misled us?
I want to apologize.
Do you agree that you misled us?
Chair, let me say to you, I didn't necessarily see it in that way, but what is proof? The proof of the meeting is that we didn't have the signed letter at the time when we informed you.
Would you agree that you misled the Committee of Parliament by telling them that you have suspended someone who has not even received that particular letter?
Chair, I accept.
Okay.
Did you say I accept? It was not intentional, because I couldn't act on it myself. So I want to say I accept, but it was not intentional.
Suspension letter.
I signed it yesterday.
Ah. Is your matter, Honorable Kwabis? Do you want to say something?
Chair, I think I'm...
No. You are still coming. You have your set. You are coming.
Chair, I think we are witnessing in real time a pattern of the board of doing things a day before we come to the committee, things that have high legal implications. They have misled the board, they misled Scopa, and now every other slide on that presentation says the matter is under sub judice, because they were unable to tell us the truth. In their back and forth, they say Mr. Letwalo was insubordinate. He refused, point blank.
I think you are getting to the discussion now. Let me ask this last question so that you proceed with your questions. Colleagues, you still have your own time. Honorable God.
Sorry,
What is your intention about the acting CEO? Because that is an act of insubordination. Did you reflect on that particular matter?
Chair, from my side, I only had it yesterday when we were at the DM's office, that he only signed the letter yesterday. So that's really what we sort of got to know. I didn't know that he had not signed up to then. So that's just my honest answer. I only knew yesterday. I thought he had already signed it.
Did you reflect on that matter yesterday when you were with DM? When you learned, between yesterday and now, what is the decision you have taken about that particular act which resulted in you misleading a competent committee of parliament?
Chair, I will say we have to take it back to board. I can't make a decision myself. The board was there.
The question is, did you as a board, because you got that information yesterday as in the meeting of the board, and probably once again by the intervention of the DM, by the time you get that information, did you reflect about that particular matter, about the conduct of the acting CEO?
Chair, I think we each reflected, but we have not met as a board to make a decision. I think we did reflect, but we do need to meet as a board and make a pronouncement on that conduct.
I hope you'll still have that time. Yeah, proceed with questions through your DM. Sorry for those interventions.
I think we were at a point where the audit committee was going to provide a response on issues that had been raised. I think that was the last segment that was there on issues around the risk and the chief claims officer and the CEO being a referee and a player.
You can pass the bite.
Thank you, Chair, and thanks for the opportunity to comment. I think this question is probably more appropriate to Regal Chair instead of the audit committee.
The question was put to you.
There is a context at which why the question was put to you.
Okay, and maybe Chair, can I please have the question so that I'm sure in terms of answering the question? I don't want to answer incorrect question, Chair.
When you say that the question is best as answered by someone, what is the question that you understood to be?
My understanding of the question that was placed before me was around the risk as well as the control around governance. So maybe to explain the lines of defense, you have the board, and the board have various subcommittees, including audit committee, regals, and amongst. A regal is your risk governance and actuarial committee. It focuses predominantly on risk matters, including assurance. But because audit committee have a responsibility by its statute, the regal committee then report into audit committee. Hence, I was answering the way I was answering, Chair.
Internal controls?
The internal control, obviously, it's our CIOA who report directly into the audit committee.
So when the matter was reported to you, I'm trying to assist you to arrive home quickly. When the matter was reported to you, because the CIO deals with internal control, and my understanding and the context of the question borders on internal controls, what did you do yourself with that matter before you passed the bite?
My apology, Chair. I don't want to mislead the committee or otherwise. I would prefer to err on the caution side and ask the question to be repeated. Honorable Member, I apologize.
Your question? Yeah.
Oh, I think we has almost the same question, but I can give context to what I was asking.
Do that.
Just to perhaps, I think, as an audit committee and a risk management committee, you do receive reports of internal audit on their audit of corporate services. I believe it should be annually because the risk level is quite high in that particular department. Now, I believe that you have received the report, and I believe that in the first few pages of the report, it states the organizational structure, the budget, and the current expenditure at that time. I'm saying the format of the report, and I'm sure you are familiar with what I'm saying. And part of that report is that it would tell you that there is the CEO is acting in this particular position. What was your take on that? That's what I'm asking. Because I believe that you were supposed to raise it as well, if you are uncomfortable with it or it was not within your risk appetite. Thanks.
Yeah, thank you, Chairperson. Once more, my apology. I think the question is much clearer. Thanks to the Honourable Member. And the Honourable Member is indeed correct that that particular report would have been elevated to the Audit Committee. I just want to clarify that within the RAF governance structure, an audit committee is not audit and risk committee, it's audit committee. However, the risk matters do have dotted line into the audit. The report that was provided in particular around this role of the acting chief claims officer, the reason that we were given were noted by the audit committee. And I think, in all honesty, we were quite comfortable with the reasons, given that that function was quite critical. We didn't see in the interim or in the short term why would the CEO not be acting in that position. And I think on an ongoing basis, the feedback that then came through after, I think it was also of evidence that there were no issues of performance within the function. And obviously there were quite serious issues around various regions to an extent that CEO warranted to act and address those issues. Thank you, Chair.
So you see you had answers and...
Chair, Chair, I want to apologize. I really apologize, honorable members. Yeah.
Okay, yeah. Who was the last?
I think
You're done.
Yeah, Chair, it's just to confirm two things, and One is that on the issues around the accounting standard, the board has requested 21 days to look at issues around the sorry, Chair. 21 days to do an analysis, an actuarial analysis on the impact that withdrawing from the court would have, and I have granted that 21 days dispensation for them to complete that work. Parallel to that is they want to do an impact assessment and the actuarial quantification on that. And then secondly is to indicate that tomorrow I am scheduled to meet with the Accounting Standards Board in order to ensure that we fast track the completion of an appropriate accounting standard for the REF. Chair, I want to reiterate the position of the ministry on this matter. We do not believe that the RAF should be in court on this matter. And we have communicated that clearly and firmly, and we have been met with a response which is simply a no. As I speak, following the SCA judgment, the Road Accident Fund is in the Concourt on this matter. And I want to clarify, Chairperson, that that course of action has been undertaken without the support of the ministry. And that support won't be forthcoming because we believe that this is a matter which, after 3 court judgments, adverse ones at that, should not be proceeding. So I thought I should place that, but for the purposes of progress, I have granted the 21 days following yesterday's meeting, and then we will be in a position to report back to yourselves on the next course of action to be undertaken insofar as that matter is concerned. Thank you.
Maybe when you're still the DM, before I allow other members to come in, was this a board decision to challenge this accounting standard?
My understanding, Chairperson, is that yes, that is the case. My understanding of the latest court action is that it is a decision of the board, but with dissent within the board.
Okay. Colleagues, we are going to take, no, colleagues, you have raised the hands, you are noted. We are going to move as follows. Honorable Van Staden, you will be followed by Honorable Ghana. Honorable Ghana will be followed by Honorable Blosse. Honorable Blosse will be followed by Honorable Montana. Honorable Montana, what is that, Mobe? You want to speak again? Yeah, I'll allow follow-ups later on.
Chair, I'm sorry. I omit something which I believe, and the ADG reminds me.
Before, let me finalize the speaking list, and then Honorable Montana, Honorable Mkompane, and Honorable Malomaj. You will come in. From there, I'm going to allow general follow-up for everyone, and then I'll take hands for that. Yeah.
I'm sorry. Is to indicate that on the question of the latest decision of the board with dissent, as a result of that decision or its construct, the papers to the Concourt, I'm advised, were signed by the CEO and not the chairperson of the board, who I'm told was not in agreement with the onward proceeding to the Concourt, and therefore the board resolved to delegate the signing of the papers to the CEO. Thank you.
Yeah, I think we have. Yeah.
No, Chair.
Just to get it clear, man. It was supposed to be signed by the chair and the chair refused to sign. May I get it clear then?
I'll ask them to explain it themselves. I want to give the report given to me.
I think let's handle it this way, DM. Honorable Malmat, you're going to have your time. Note it down. You will follow up at that particular time. I think it's a contentious issue that the judiciary duties of the board. I think, Honorable Van Staden, you can shoot. Honorable Malmat.
Thank you, Chairperson.
Thank you.
Just to take note that board members must take note that to mislead the Portfolio Committee of Parliament is a serious offence, and personally, intentionally, provides false or misleading information or statements to a committee can face penalties, including fines and imprisonment. So bear that in mind. Upon your presentation to us tonight, I want to know what is the reason why the Road Accident Fund lost plus minus 25 million rand due to the fact that the fund failed to defend against claims in the court, which results in default judgments. It is also known that the fund often do not send legal teams to court, and therefore the fund do not have legal representation. I want to know what's the reason for this. And on slide 30, you show an amount of last year and this financial year in a total of 3 million rand. Does this not result that public funds goes to waste? Yesterday in the Pretoria High Court, the judge said that the Road Accident Fund made 3 false allegations to the court that this is a serious problem at this stage. I want to know what is the reason for this. And the failure of RAF to carry out its constitutional duties leads to major problems. I want to know, is there a chaotic approach in terms of litigation at RAF? In other words, I also want to know how does your, and want to understand how does your legal department function at this stage? My last question, Chair, will be, what are you going to do about the claims that you did not register but are returning as default judgments? So I want to know, what about those victims' rights and payments being withheld due to your notices? That's it for me, Chair. Thank you.
Ghana?
Thanks, Chair. I wanted the DM to be here. I don't like these long speeches. I don't have the energy for the long speeches. DM, thanks very much. And the board chair. When is the contract of the current CEO expiring? I want an answer. No, I want an answer, please. I only have 3 minutes.
Ghana, let me stop your time. Ghana, through me, please.
Hey, thanks very much.
Yeah, load your questions.
I'm asking for 3 minutes. In the 3 minutes that you'll have allocated me, my questions will be asked and answered.
Okay.
Yes.
My problem with that is that if everyone would want to take that approach, we're going to have a dialogue.
It's 3 minutes.
Just ask questions.
No, Chair. I know that I don't want for us to end up in that dialogue that was happening with the acting CEO. I want to flow with my questions. I'm going somewhere. Please allow me. In the same way that you arrived at that interrogation with the CEO, with the acting CEO, because what was being given was not adequate. I'm asking for 3 minutes to have a conversation with Raf and the Deputy Minister.
I don't think we must move in that way, Ghana.
I'm asking.
Declined.
When is the contract of the current CEO expiring? I'm requesting for an answer.
What's the next question, Ghana?
No, Chair.
It is not going to happen that they'll answer you.
Chair, with the utmost of respect, I believe that what your ruling in this particular matter is not assisting us in holding the board and the executive accountable. The reason I say this, Chair, is because when there were none answers given, you could ask follow-up questions. I don't want to come back. I don't wish to come back. And my questions are related to the first question. And if that first question is not answered, then it means that I will be not asked the questions in the way that I want to ask them.
You are at liberty to ask questions. I'll allow you to come back. Feel free to come back.
How many minutes do I have, Chair?
You have 3 minutes, but you'll have other minutes to come back.
Let me use 10 seconds, and I'll come back for the 2 minute 50 second.
Peace.
When is the current contract of the CEO expiring? And whether you have or you intend to advertise for that position. I'll come back and finish my 3 minutes, Chair.
Very much. Next speaker, it's Honorable Montana. No, it's Honorable Blose.
Yes, thank you, Chair. Chair, I don't have much time, and I'm not going to waste my time with the board. Chairperson of the board, did you mislead this committee when you were supposed to come to our virtual meeting last week? Why were you not in our meeting? The deputy minister, you misled him. He gave a report of your absentia in that meeting. And you misled him because what he gave in that meeting was untrue, because someone else said there, the reason you were not in the meeting is because you had a previous board meeting the previous night, which ended very late. But the deputy minister gave us a different story. So why were you not in our meeting last week? That's one. Two, on the day of our meeting, you were working. You signed the special leave rejection, or whatever the thing that you guys were advised of. And you also signed the suspension of the CEO. Again, Deputy Chair, you prepared a report and came to our meeting and told us that the CEO is suspended. And the Chair asked you in that meeting, has the CEO been told that he's suspended, as you are telling us? And when you said yes to us. But you didn't have a signed suspension letter from your chairperson, because our meeting started at 8:30. You didn't have it when you communicated that decision. Again, you lied to us. It is a board that keeps making wrong decisions. You placed the CEO under special leave. You were told by a legal opinion that the decision was wrong. But the legal opinion did not tell you to suspend the CEO. Again, you've taken a wrong decision. And I feel that DM, you are interfering with board decisions, because you ought to leave the board to do its work. And if they take wrong decision, then you charge them with insubordination. Because this hoo-ha now that the CEO is charged with insubordination because he did not attend a SCOPA meeting. It was a board decision not to attend a SCOPA meeting. And DM, you interfered with that decision. And the board sitting here, I'm asking you, Chair, do you have a resolution of the board to rescind that decision after the deputy minister had instructed you? Which meeting? When did you sit a meeting and rescind a decision that you are not, that now, on the instruction of the deputy minister, you are now going to attend SCOP? Because now the bulk is placed on the CEO. Okay. Direct question, Chair. Is the CEO suspended for the SIU report? Yes or no?
Let's move towards.
Chair, I've got 30 seconds. I've got 30 seconds.
You don't-
Okay,
You
Chair.
don't determine your own minutes.
All right, Chair. DM, the board took a resolution to reappoint the CEO, and they did a 360 evaluation on the CEO. That report the board has not finalized. You have instructed them to go and re-advertise for that position. I don't understand. I don't know if DM you have got the legislation mandate to do that. Is that not interference? Because again, the board is taking a lot of decisions that now are being rescinded. The board took a decision to go and challenge the issue of Discover. They won against that issue. They took a decision to go and challenge the issue of SARS. They got an interdict on that issue. They took a decision to go and challenge AG. And the ministry is coming again and saying that the board must let go of that decision.
As you move towards conclusion.
So I don't. But Chair, I'm closing.
Finalize, close.
I'm closing, Chair. Acting Chair. Acting Deputy Chair, I mean, my final point, Chair. You've got a tendency of where you lead to create unnecessary chaos. It's the same thing you did at Pick It Up with Amanda Nia. You charge that woman for things that are illegal, and after you've charged her and suspended her, it was found that she did nothing wrong. We see the same trend now happening here at Road Accident Fund, of which we understand that we are at the center of all this chaos.
Thank you, Honorable Blosa. Yeah.
Can I not complete, Chair?
We have completed the question. Honorable Montan.
Chair, that's very, thanks very much, Chair. I think as an elder in the committee, Chair, you'll give me more time.
How is this eldership counted?
Well, we'll do it after my 5 minutes, Chair. Let me be quick. Chair, I think, let me start where we ended the last meeting, on the 3rd. We said the board, the entire board should come, and I think that the Honorable Malimeja said, you must tell us, convince us, demonstrate to us why we shouldn't pass a motion of no confidence in the board. That was the conclusion of that discussion. And I think that listening to the discussions, I still don't have the assurance about whether, we are on the right course. And I think that 3 things, Chair, that we should use as measurement. The first one, did the board mislead the committee? That's the first issue. Did the board mislead the ministry? That's the second issue. And these questions are very important in what to do. And I want to pose some questions starting with the Deputy Minister, to the board, and to the acting CEO. Deputy Minister, the issue raised by Honorable Bloss is very important. You, in the last meeting and today, you have made an assertion that everything is wrong. There's quite a lot of, or let me not put it in absolute terms, you actually gave us an impression that there's a big problem at REF. The chair at that meeting had actually asked but when we were there, when we visited the REF in October, we were given an impression that this is an organization working in a particular way. The entire board is here. You see, the board can delegate, but it can't abdicate. It also cannot abdicate to the acting CEO. What is within the realm of the board remains there. So if you come to us, if let's say the CEO, acting CEO, or CFO didn't deliver, you can't say it's a CFO. Ultimately, you have to put in place the strategies, the controls, and all of those things. So I think that question about risk becomes very crucial. And I don't think that you should do that. So the issue that we must assess where we misled. Number 2, if the DM says there's a problem with the REF, why is it contrary to the view that was presented to us in our visit? And I think that in what has been going on in social media, we have heard, for example, the speech by the board chair recently with the results. And I think that maybe we should play the speech. You remember at Scopa, stuff were leaked, and the chair spoke about that at great length. Also you've created a culture where staff leak stuff. So they've leaked to us, and if you listen to in the results of the result, I could play it, it's in my own thing here. where the chair said, we are doing so well. This is such a grave contrast between what the deputy minister is saying, okay, and what we're getting an impression. So it's either the deputy minister has done an assessment of the performance of the ref that is objective, we can look at indicators, or we can conclude that the board misled the ministry in terms of its own performance. And I think that is very important. That's a very important issue for me.
Yeah, let's wrap up.
I'm about to wrap up,
Yeah.
Chair. So, Chair, I also want to check. You asked a question at the meeting to the Deputy Chair whether as we were discussing on that day, the letter of suspension had been given to the CEO, and I think that we got a confirmation. I just want, in the light of this one about the CIO, is very important. And the acting CEO, I think that perhaps you need to indicate to us when exactly did you get all these instructions. You signed yesterday. I just want to have a sense about all of these things. And Chair, my last shot is in the light of what the Deputy Minister said about the board and the resolution on the standard issue. I just want to hear, because he said is the chair of the board. We've got members of the board here. They haven't spoken. We don't know what their thinking is on this issue. Because I think that for me, I want when I stand here to have the assurance that we've got a board that is really managing this entity. But as I see it right now, I'm actually worried that we are not getting that. And I think that what we wanted to propose to the Deputy Minister and therefore to the ministry,
thank you,
that we pass a motion of no confidence in the board.
Thank you.
Because that's what we need. That's what we spoke. But
Thank
we
you,
need to see
Honorable.
the answers.
Thank you, Honorable
Thank you, Chair. I
Montana.
thought
Thank
I'm
you.
still the elder, but I realize I've been demoted, Chair. Thank you.
Ngomban, Honorable Ngomban.
Thank you, Honorable Chair. Chair, let me appreciate the report and also the honest and progressive comments by the Deputy Minister when doing his opening remarks and also indicating that there are difficulties at RAF. And the situation currently is not good. And also, in the same vein, I would like to appreciate the powers given to the committee by the rules, as that has been mentioned by the chairperson of the board. Quickly, Chair, my questions. I thought perhaps I would be given the reasons, because they outlined the SIU investigation, timelines, process followed, then reasons and policy provisions. But I couldn't hear the reasons, if we may be appraised on that. I leave the budgeted post, Chair, and the vacancies of the chief positions, the 3 chief positions. I think we need more here to say when perhaps will these positions be filled, because the chief claims officer, the chief corporate support officer, and chief investment officers are very key for the entity to function. Chair, on outstanding personal claims and direct claims versus legally represented claims, there was a say that from the acting CEO, to lodge a claim, one has to be a lawyer. What does that mean when a person is lodging a claim when he or she is not a lawyer, a direct claim? What does that mean? Then, Chair, in 2015 to 2020, the target was 1,440 days. in 2025-26 is 120 days target. Then there is a silent period of 2021 and 2024. What was the target? Those financial years. Then lastly, Chair, yes, on the second slide before the last one, that is slide number 37, there's something there that has been written, CEO post advert. But below, it doesn't talk about the advert of the CEO post. What is the meaning of that heading? Thank you, Chair. Oh, the last one, let us request, Chair, to be supplied with the owners of the leased buildings, all of them, not only the Johannesburg ones. We are interested to know who are the owners of the buildings in Durban, in East London, Johannesburg, and all those areas listed there. Thank you, Chair.
Thanks very much. Honorable Malmaja.
No, thank you, Chair. Let me also follow suit and welcome this really embarrassing kind of presentation. One, in your own presentation, you said for a period of 10 years, you have spent plus minus 854 million for release. The question will be, at what point do you realize this was wrong? And why now, and why you want to give it to the CEO as if he's the only one? Then if you realized earlier on, why should we still keep you if you cannot save such funds? Still on that, you talk to us, how far are you with the court order where RAF has to pay 1.4 million to a Malawian? And how many of these foreigners are really getting this money when the South Africans are still queuing? Because your own selves is like you're not sure in terms of the papers. Chair, the earlier incident demonstrated very clearly, without any doubt, that this board that we're facing today is not assisting, and it will never assist. You have an acting CEO who is very fast to take us through, but when coming to responsibilities that can put him where he's supposed to be, he can't sign. You have got the acting chair who is time and again lying to us, and who is very agitated when we deal with the matters. If she wants me to prove that, on the 3rd of June, when we had a meeting, we asked her for about and halfway of finishing the meeting. It's only then she said, then the chairperson has got the family issues that she cannot make it to the meeting. And I want to tell and put it to chairperson that you have deliberately decided not to come to that meeting. That is why your apology was to be manufactured in a way that today we are here, and I'm still saying, why should we keep you? The very same reason that the Letswalo CEO was suspended because he did not attend other meetings. Why can't apply that to you? DM. In many cases, it's unfortunate legal routes this baby, but I will have to do this. A parent who's overprotecting end up in trouble. When we were here, we are trying to get exactly what is happening in RAF, where you too, you also accept that there are problems. You want to profile yourself as if you can defend everything. We are telling you, in front of you, they've embarrassed you, these people. You had to stop, you have to come in, you have to seek and dig for the truth. And it's not what we're expecting you to do. We're expecting you to crack the whip. And when they come here, they must be honest with us. We're not here to play. These people are getting money of the CEO. He must tell us everything that we're supposed to do. Actually, it's not by favor. Portfolio committee, everyone who touches anything that has to do with transport is accountable to us. Yourself, the minister, and this board. And if we are not happy with this board, we must tell you that we are not satisfied. We want them here. If we are to put so that the public can know why we invited Mr. Letswalo, is exactly what the earlier incident by the CEO prevailed, where we could not get exactly the sense of what is happening. Chair, when it suits you, the law applies. Yeah? When it so too the law applies. We are telling you that by the time Mr. Letswalo was sent home and other things, some other papers were not signed. Here again, you are attesting to us that you suspend the CIO without even
As you
having a written
conclude-
letter on that.
As you
And
conclude,
that-
Honorable Malmat.
And I agree, Chair, when I learned this board, that question hasn't been asked. Do you see yourself still relevant, can be kept by us? Give us the reason why we must not dissolve you. Thank you, Chair.
Thank you, Honorable Malmat. Yeah, I think I've captured everyone. You lead the pack once again.
Chairperson, thank you very much. At the very outset of this meeting, I indicated that yesterday I had a full-day meeting with the board. I'm compiling a report with the ADG and I'm considering my options. But there's information and issues which are still outstanding. The second point, Chair, I'm not sure of this very grandiose characterization that I'm interfering. The decision of the board to place the CEO on special leave was a decision of the board which they communicated to us. Honorable Blosse is a member of SCOPA, and he would know how I reported that matter. One thing, Chairperson, I'm very clear about is the fundamental difference between interference and interface, and the absolute responsibility that we have to ensure that there's due compliance. It is not interference to tell a board to come to Parliament for it to account to Parliament. What was I supposed to do? Smile and wave and kiss babies? When a board of an entity within my purview takes a wrong decision, which I've repeatedly said that it was wrong, to go to a meeting which he, Honorable Blosse, is a member of. That's the second point. Thirdly, I have a responsibility to ensure stability in entities. The contract of the CEO ends on the 6th of August, 2025. Recruitment processes take a long time. I'm saddled with another entity where we have not been able to appoint a CEO, and that has given me the experience of why it is necessary to make sure that things are done on good time. I requested a full and comprehensive list of the expirations of the CEOs and the boards within the purview of delegations which we have presented to this committee. Now, the minister has to appoint a CEO on the basis of a recommendation from the committee. All of us here who are public reps are elected on a 5-year term. And we go and subject ourselves to the biggest panel there is in this country, the electorate, when that term of office expires, for it to make a determination of what it does with us. Somebody who applied or wanted to apply 5 years ago and did not meet the requirements and meet them now has got a legitimate expectation that when a contract ends, they will be considered if they apply and meet the minimum requirements. Ukhuluma ngo 360 ke and evaluations. If he has that report, good for him. I don't have it. What I have asked the board to do.
What is that, Honorable Bloss?
Chair, I asked a question in that. So the DM must not say it's my report. When I made that articulation, I asked the question to the board. Do they have a resolution to reappoint, and have they done a 360 evaluation on the CEO? It's the question the board must tell us.
No,
so the DM must not pack it back to me. I put it to the board. I need a response from them.
Honorable Bloss.
So it's not my. It's a question I asked.
Honorable Bloss, thanks for the intervention. It's fine. You don't have to. to be emotive on it. Yeah, that's the context, Honorable DM. This question is not.
Nonetheless, Chairperson, it's two sides of the same coin. He says that I'm interfering. I'm interfering when I'm asking the board to follow due process, when I'm not implementing the due process. I'm saying to you, Chairperson, if the CEO, whom has a contractual relationship with the entity and his term of office expires and has a wish to continue as the CEO, he must go through the process like everyone else. How is that interference? I say this, Chairperson, because over the weekend there was some tweet about all sorts of manner of things coming from members of parliament. It's saying we have taken decisions that we have not. You see, Chair, what is going to collapse this oversight responsibilities is an outlook to want to be a player and a referee. My only expectation is for the board to ensure, already now we are in June, we have to now ask ourselves the questions, what happens on the 6th of August, right? And that's why I say there's a responsibility for stability. And I stand by the outlook that we need to advertise because the term of office will expire. It's a contractual obligation, relationship. I mean, unless there is some magic wand that can be waved outside the act. But what I need to do, because by the way, Chair, maybe for clarity, all submissions in the Department of Transport on any matter come via the departmental structures that ADG and myself and go to Minister. I must be in a position to advise the Minister correctly, and I intend on doing so. When I receive a report from the board on the due processes that have been followed for the purposes of filling the vacancy of the CEO of REF. As we are seated now, we are currently in the process of advertising, as the advert is already out, for the board of the RTMC, so that we've got a lead time, so when it expires, we are able to fill the vacancy. We have gone on far too long in government, in my own assessment, where we leave things to the last minute. It will not happen under my watch. So if that is interference, then charge me. Charge me.
DM.
Yeah. Then, Chair.
DM, that part, we don't charge. We don't. So you are daring us to charge you now. Don't go that direction. Just continue to provide answers. Yeah.
Then, Chair, is the issue around...
Just DM. Honorable Mutan.
Chair, can we tariff so that the DM deals with this thing properly, in the proper context? The question is, in filling the position of a CEO of an entity.
Speak to the mic.
Sorry, in filling the position of a CEO of an entity. Is that the responsibility of the board, or is that the responsibility of the department? The board comes to a determination. It recommends for cabinet concurrence. So I think that it is in that context that Bloss is raising this issue, DM, not all the other issues that we are addressing.
Covered. I think the point is covered.
Chair, let me start.
Do you still want to say something on it?
Yes, because
Okay.
there's a... No. Chair, I asked for a schedule of boards and CEOs. The lead time of the due processes is long. I asked the board to begin the processes of the filling of the vacancy so that when we come to the 6th of August, we have gone through all the processes. We are not to start on the 6th. That's point number one. Secondly, the board will recommend to the minister. And I will ensure that the minister receives that recommendation, and we will take it to cabinet for the minister to appoint. It's the minister who appoints. And all I'm saying is, the minister delegated entities to myself, including REF, in the assist of the exercise of her responsibilities. And I am indicating here that where vacancies are bound to arise, we are to fill those vacancies. It's as simple as that. And what I'm saying is that it must happen because there is a contract of 5 years. I have not said I'm going to advertise. I've not said I'm going to interview. All I've said is do what you must so that we can be in a position to fill the vacancy when the time arises. It's elementary, Chair, it's common cause, it will happen. And I'm saying, Chair, in the SCOPA meeting where this matter arose, it was raised in that meeting, the latest developments insofar as the substantive CEO is concerned, who is now on suspension, are quite apart from that. They are recent. My correspondence in Dala on this matter. So the two are not related. And I indicated, and that's why I kept on emphasizing that in my view, the special leave is without prejudice. But it must go through a process.
I think that
Then
point
lastly,
is
Chair,
substantively covered now.
Lastly, Chair, I'm accused of interference insofar as the board decision is concerned about coming to Parliament. No, I don't think so. I think I was doing and will continue to do what I believe is right, that when called upon to do so, we must appear before Parliament. You will know that yesterday I brought to your attention that we have this legal conundrum of the matter being in court. But we are here today with the board. There was no, overtures to say, can we postpone and so on, and ultimately we came to the decision that we must appear before Parliament. Is that interference? Because I think, Chair, what I will not accept is characterizations which are baseless, which seek to cast aspersions on myself. We go to the issue that is being raised about SARS and court. When I was briefed by the board chairperson, after they wrote to me that there's a 5.1 billion rands matter, and the intergovernmental mediation was to proceed, and the board said that they're going to court, we gave them the support and the green light to do so. So, is that interference? I think what we need to distinguish, Chair, is that the issue of the accounting standard is ultimately wrong. It's completely and utterly wrong. Because what will happen next, we're going to be called here, and it will be the very same committee that says, on your watch. You see? Now, let me then say this.
Yeah, wrap it up there. Honorable Montana, I'm not sure you still want to make that intervention, really.
Is to say, Chair.
Please, Chair, so that when the Deputy Minister, because I think, I don't want us to speak past each other, Chair. Let's clarify this issue again, DM.
Maybe hold it there, DM. Yeah?
Can we clarify this issue, Chair? Because DM knows that even at the personal, professional level, we've got huge respect for him. Let's deal with the issue. When the DM says this issue of the standard don't go to court is wrong, okay? What's supposed to happen? And he said himself that he's still going to meet the board that determines the standards. The board must do the work. You see, what he can ask is that the board should stay.
Honorable Montana, hold it there. I think you are revisiting the question. What we will do, we're going to allow you a last roundup because otherwise we're not going to finish We're going to be intervening on each and every matter. He's captured now. I think he's going to respond to it now, and then as you wrap up on these matters involving you, DM.
Yeah, no, Chair, we've traversed a very long journey on this issue of the accounting standard. And as I've indicated here, is that the board has asked for 21 days. It's as I've indicated to you that the board, there was dissent to the extent to which the court papers, I'm advised, ended up being signed by the CEO to go to the Concord. So, and the position holds to say the AG has made a determination. The ASB informed Parliament. You can pull out the records. Informed this institution, the Office of the Accountant General, National Treasury, the previous scoper, on the basis of outlook on the issues. Now, what has ultimately happened is that the board has arrived at a determination to say they want 21 days, and we've granted that 21 days in an outlook to say how do we, in a responsible manner, facilitate the withdrawal of the court action and apply the standard as it is now, at the same time find an appropriate standard. But above and beyond, it goes to the issue I've raised before. We are in the process of a legislative review, and we are en route to bring a bill to Parliament on the issues of the road accident fund, so that. Now, lastly, Chairperson, what Honorable Malmacha says is absolutely correct. My interventions do not seek really to protect REF, but what I'm trying to get at is for REF to subject itself holistically to oversight and accountability to Parliament in order to enable Parliament and ourselves to take the correct decisions. And that is the start and end of it, Chairperson. And we will come back to the House on a roadmap that we will develop. What you must know, Chair, yesterday I had a very, very extensive meeting with the board and the executives. Very extensive. I am still seated here, settled with the fact that there are whistleblower reports which have come my way, which have come the way of Scopa, which completely and utterly change the outlook about their issues and affairs at the REF, of which now I am trying to have them tested correctly so that we can apply the applicable remedies to it. Issues around corruption, maladministration, misrepresentation of facts and information submitted to Parliament. But what I won't do, Chairperson, is take hurried decisions without having undergone due process. So when I say, Honorable Montana, that all is not well, I say it because what has transpired extensively and exhaustively in the last few months, and specifically weeks, is a concerning situation. And it's also, Chairperson, precisely why we believe the legislative reforms are necessary. Because the flip side of the coin is that beneficiaries and claimants are struggling with the lawyers. They are absolutely struggling. We are saddled with high bills of foreign nationals in the country, which come in and then get money. And so every single day, Chair, our phones are being blown up by complaints. We have instituted a process with the Deputy Minister of Justice to intervene on the judicial matters of the processing of claims, as the report says specifically in the Gauteng division, amongst others because of those concerns. So when I say that the situation is bad, is because we need to look at the entire ecosystem, which is inclusive of the audit outcomes, the performance indicators, the operations and information that we have at our disposal. Thank you.
You can pass the bite.
Chairperson, you will delegate the board and the executives as you deem fit.
Thank you, DM. Honorable Chair, let me start with the matter of the meeting of the 3rd of June. When the invite from PCOT came, I already had a personal commitment to take care of a terminally ill. I'm sorry to say that now I did say personal matter of a terminally ill family member who have since passed and will be put to rest this weekend. And I couldn't walk away from that. The first thing I did when I received that, I wrote a note to all the board members. I think the board secretary will communicate that. And I said to them that the deputy chair will attend because I have a personal commitment that I can't cancel, that needed me to be available at the time. I couldn't walk away from that as a woman in my age and responsible, because some women, I don't know whether I have to go through that, but there is evidence. The board secretary will give you. The only mistake that happened was that he omitted to write a letter of apology, which should have followed, because there is the administrative aspect that the board and secretary does in terms of communicating with the various structures. And I even sent a note to the deputy minister as well, informing him that I'm unable to attend. That WhatsApp is still available as well. So you will get those documentation to say that I couldn't walk away from that. And that's why I delegated correctly. It's not like I did not want to come. Okay, sorry, can I just finish? And then...
on that, Chair, because I don't want the Chair to move away from that.
No, I'm not moving away from that. Sorry.
Just hold, Chair. Honorable Bloss.
Yeah, but she must not do that as well.
Oh,
Chair,
sorry.
in the meeting...
Address me.
In the meeting, Chair,
yeah,
the DM gave that explanation that she's giving now. And the question was that the Secretariat has not sent us the apology. And then there was a person who was in the meeting with an something device. That person must reveal themselves here. Who gave a different explanation as to why that thing is on record. They said that last night we had a board meeting that ended very late, and because of that, that's why the chairperson is not here. It's on the record. So they must confirm to us here, because that's what I'm disputing.
Yeah, it's noted. I think they'll come to that. You'll have to deal with that. Yeah.
Yeah, Chair, what I try to explain is that maybe two contexts. The chairperson of the board is right. In two instances, when the special meetings of the board were held, she actually communicated. That will actually be provided for in the minutes. So what I was simply saying is that is in terms of my liaison with the Secretariat of the PCOT. So what I was simply saying is that because the meeting of the board ended around 11 o'clock, I could not get hold of the Secretariat of the PCOT actually to communicate the apology. But I said to the members to say that in future that particular deficiency will be addressed. And we've actually addressed that because Chairperson, already a day before yesterday, we communicated two apologies to the Secretariat of the PCOT. And I apologize for the late communication of the Chairperson's apology, Chairperson. That is the matter for the record. So it's something, it was the board Secretariat of the RAF. Thank you very much, Chairperson.
Okay. You are fine now, isn't it? Yeah. Chair, you can get out of that one. I think it's clear now.
Thank you, Honorable Chair. And Chair, the second matter regarding a possible lie, the fact that I stated that the RAF is performing very well, that is on record and audited. From 2019-2020, the RAF recorded 57% in performance of its APP targets. Last year, we recorded 84%. No, the year before that, which was audited. And then this current year, that 2024-25, it's sitting at 85%. That is the unaudited performance results. From the time the 5-year strategy started, all the performance record of the APP have been audited by the Auditor General. So those numbers are factual and correct. The only year that hasn't been, that is currently undergoing audits, is the current year, which is sitting at 85%. But all our performance, our APP performance record, have never been qualified by the Auditor General. So that is a matter of fact. There's a difference between performance and misconduct. Most of the issues that we're dealing with now relate to matters of misconduct. But a person can perform, and then there could be areas of lapses in conduct. So I think those are two different things. So that wasn't a lie, it's a fact. You'll see the unaudited APP performance is sitting at 85%. And it's also on record that this board actually put almost 50 billion in the claimants' pockets in the last 5 years. That has never happened before in terms of bringing in efficiencies in the processes. We've taken a lot of money out of administrators and put it in the hands, in the pockets of the claimants, who are basically our core in this organization. That has also been shared over the years in terms of progressively the savings and the claims payments numbers, over the 5 years. So again, that is undisputed numbers that in terms of the performance of the organization. Yes, we've accepted as a board that there's a lot of challenges still existing in terms of, dealing with certain matters of in the RAF. We accept that, and there are, we basically looking at it with open mind and also putting in new strategies to deal with those things. And matters that we can fix immediately, we're doing that. I mean, with the current positions, we did say to the acting CEO, please, we gave him 4 months to fill the critical executive positions. Then we said the vacancies, fill them temporarily with experienced people so that there is no gap. We're not looking for, challenges now that, you have people acting, but they don't have the competence and the experience to do that. And he has, even including the head of legal. The head of legal was there. It's just that the person was not given a proper acting appointment. But she has been working in that environment. So we've been very clear. Even the matter of the acting CIO, when the matter came to us as a board, we commissioned the REMCO subcommittee to go and do a preliminary review on that. And they came back and confirmed matters of misrepresentation, non-disclosure of critical interest that really confirm integrity issues. And there's additional, substantive matters that came out of that. That's why the board, after following, also getting legal advice on that one, took that decision to place him on suspension. So low-hanging matters that the board could actually deal with, we have been decisive in terms of dealing with those. Thank you, Chair. I think the CEO will deal with the operational matters. Thank you.
Yeah, thanks, Chair.
No, Chair, I just need clarity. Who's going to deal with my question of the reappointment and evaluation of the 360? I'm asking because now it's passing to the CEO, so who's going to deal with that? Because that's a board resolution. I specifically asked about it.
You would have realized I've not even agreed that you must speak. And I don't think that's fair for the meeting, because if you were to do a follow-up, you would still do follow-up on that question. I don't think now you are being fair to the meeting, Honorable Bloser. But perhaps if you could quickly deal with that, Chair, so that you can pass the bite when we've exhausted that.
Honorable Chair, I did state that I can't answer questions that affects the current case. But what I can say is that once the court papers are out, probably by the end of this weekend, some of the answers will come through. I mean, members will be able to read those court papers. But I can't
Thank you. Yeah.
Thank you.
So you answered on that part. The matter is sub judice. See you.
Yeah, thanks, Chair. I think the first question I think specific question was from Honorable Montana around the timeline around the CIO. I think I am not going to make the mistake and detail that. From the instruction of the letter that communicating that the board had resolved to put the CIO, acting CIO on suspension, was sent to me on the 3rd of June. It landed around 8 o'clock in the evening. Obviously, that was after the meeting, the portfolio committee meeting on the 2nd of June. I did
repeat that.
I'm saying the letter to suspend the acting CIO was submitted to myself on the 3rd of June, 8 o'clock in the evening.
Not in the morning.
Evening. I then replied the following morning, registering my reservations that if I was to execute this in my capacity as the acting CIO, I have a responsibility to, at the very least, consider what the board would have considered in arriving at that decision. Subsequent to that, obviously, I was warned about the possible delay of executing this decision because the board had made the decision. But I was never going to be a rubber stamp to that decision. That was my position, and it is for that reason that I decided to apply my mind to the matters until I received the file, did my own assessment with the internal ER within the organization, and as I indicated that in the circumstance, I will be a charging manager who must appear before the CCMA when the matter unfolds. So I think that's the position. And if obviously that assertion is considered insubordination, I'm prepared to face that particular charge because I don't think I'll do it any differently. If it happened in the circumstance. I made the point that when the announcement was made, when the presentation was made to PICOT, we received it and we received the announcement together. This acting CIO was sitting with us in the boardroom. So it can't be correct that to expect that then you must then consequently just sign the letter, and therefore, if you don't sign, then it becomes a problem. So I think I just thought I should address that. But in terms of the others issues, I think there were just two other operational issues. I think that were raised around the specific targets. And whether or not the 120 days target, when did we start implementing it? I think we started implementing the 120 days with the strategy 2020-2025. I think the 1,400 target I referred to was in the previous strategic plan of 2015 to 2020. I think that's the main issue there.
I've seen your hand. You'll come in.
Yeah, you can come in.
You'll come in later on. Yeah. Maybe before you leave the platform, just for the purpose of record, as acting CEO, do you sit in the board?
Yeah, all these meetings that have been referred to, were special board meetings, in camera board meetings. So ordinarily we sit in open board meetings, but not in the in camera meetings that we're discussing, amongst others, the issues around the CEO appointment or suspension.
Okay, sure. If you can come in.
Yeah, Chair, with respect, I wish just to place on, I wish just to place on record, Chairperson, there seems to be a confusion. If you go to Hansard or check the presentation that was made by the Vice Chairperson, this is the Vice Chairperson said that the board recommended not resolve. Because the understanding of the board at the time is that in terms of delegated powers, the decision to actually implement lies squarely with the Chief Executive Officer. So, but I just want to put on record, Chairperson, to say at that time it was.
You must assist us, Secretary.
Yes, Chairperson. Yes, Chairperson.
We are very normal. We know what the chair said, and she did not dispute what she said. She said the CIO is suspended. Yeah, and she confirmed that. Yeah, I don't know what you are trying to do now, Honorable Ghana.
So I will have asked, Chair, in my line of questioning, when did the acting CEO get appointed? Which meeting appointed the acting CEO?
Chair, if I just in the chair is just walking in, we appointed the acting CEO on the meeting of the 27th of March. No, sorry, not March, May, 27th of May.
No, it's fine. Let them finalize. I think I understand why you are all raising and I understand why you wanted to throw questions directly now, because it's now even more confusing.
The manner in these things are sequential, and if I speak for 3 minutes, then there's no sequence. Because what you will start realizing, Chair, because now I'll ask the CEO, I don't know who answers this question, to say, in the EXCO now, at the time of appointment, how many people will have qualified to have been a CEO, considering the number of acting positions at the EXCO level? And at the moment, how many at the EXCO level of RAF are actually not acting in their positions? And you'll find that there are like 2 or 3. You have an EXCO that's acting. Now, if Chair, where I was going to go to, in that response around the board, the delay in the acting, what do you call, implementing of the decision. Let's say the board decides that the acting CEO has its insubordination. You use those words. Then you start to realize that you are running out of people to act in acting positions. That's where you are getting to. Because like if you look there, it's all actors.
Okay.
And Chair, as a last, maybe to end with this. There's these marketing contracts, as it was revealed to Scopa, 2 of them, worth 500 million. You know them. You gave Scopa that. Who will have been the person that signed those contracts in this whole acting? Because I don't know who's acting where now. Who is the person responsible for signing these marketing contracts and advertising contracts at RAF at the moment?
Yeah.
And what's the level of vetting? So as a last, when someone is appointed to an acting position, what level of vetting is done? Because that acting CIO, it's clear that there was no vetting. And these acting positions are used to say, no, you can come act, there's no vetting. We'll only vet you when you are appointed full-time. As a result, you've got positions that remains vacant and there are people acting for a long time because there's no vetting for actors.
Yeah, you were following up. Let's leave it there. Let them answer. I've seen your hand, Honorable Mabena. Then you can then follow up. You were passing the bite, but there are supplementary questions that were relating to that. I'm not sure whether they are going to the board or they are going to yourself. I can't see you there, but I saw you wanted to intervene on some answer.
Yes, Chair. Thank you. Good evening, members. Chair, I just wanted to answer on the issue of the foreign claimant. That is a Malawian claimant that's claiming the 1.4 million. That's Modao case, and we've appealed it at the SCA. That's part of our issues to say that we need legislative reforms in terms of payments of undocumented foreigners that we're busy with. So it's at the SCA. Secondly, Chair, I just wanted, because the issue around who signed the papers to the Concord with regard to the AGSA matter, that there was a dissenting voice in the board meeting. I would just like the COSEC, as the keeper of secret and knowing what really happened at the meeting that we are all in, to that just make it clear to the members here what had happened at that, because there was no dissenting vote there in that meeting. So the COSEC to please just clarify it in terms of governance-wise. Thank you.
You're part of the board?
We were in that board meeting as executives and the board deciding on what's the next step in terms of going, are we going forward with the AGS matter or not? So I'm not part of the board, but the executives are invited to board meetings. So we were there when the board made a decision on this matter.
DM, but do you see what we are now subjected to?
Chair, let me, you see, Chair, yesterday, amongst others, this is precisely, maybe let me be this candid so that I don't have to come back again. We are settled, Chair, at REF with the following. A divided board.
Okay.
We are settled with sharp differences on issues, and we are settled with the board and executives whom no longer, in my opinion, work well together. If I were to use a political term, I would say factions
in the
board are about in REF as an ecosystem, board and executives. I used the term earlier on, uktibelan, and how I put it in English. And this was very clear yesterday. That is, and this is why I keep probing as I do. So that it's clear what, you see, let me, the Scopa meeting was a similar scenario. It's accusation and counter-accusation. So that's the bottom line. And I don't think it needs to be said because it's categorically seen.
No, it's fine. So I just wanted that intervention.
Let me then say this, Chair, on this issue. The Secretariat and the board can take you through the sequence of the issues around the Concord. But yesterday, yesterday, the issue of the papers was put to me by the board and the executives that the chair didn't sign. And she indicated that she didn't agree that we should continue. Manjege, if that's not dissent, then what is it? This is, Chair, this is ultimately...
So you are equally picking here with us now that there was no dissent. Is
I'm
what you're
saying to you, Chair, yesterday, I was informed. So what I'm saying to you, Chair, is that the chair was not in agreement, including what they're reporting. And therefore, the board delegated that the CEO should sign.
Okay.
And if Bepiga, Chair,
DM,
it
there
will
is a-
tell me everything I need to know about yesterday.
Yeah, no, it's fine. Madam at the back.
Thank you, Chair. I think the Chair can clarify this. Yesterday in the meeting, she said the board voted in favor of continuing to the Concord. And in that meeting, there was no dissenting vote. Subsequent to the meeting, she had her doubts, and then she decided not to sign the papers. So in the vote to go to the Concord, she did not have a dissenting vote.
Thanks very much.
May I request just one thing?
Yeah.
She's here.
Look, you know, you are subjected to this and that, counter say. Now you will then appreciate why we needed to have this type of a conversation. Imagine the embarrassment we'll suffer if we were to meet with Scopa, having to do oversight on this committee, appearing in Scopa, meeting this type of understanding for the first time. Untitled, you are not a participant on this one. Your time is coming. You still gonna, I see you are busy raising your hand, Untitled. We're gonna come, we're gonna give you an opportunity. We're going to ask you questions. Honorable Bloss, I'm ruling on this matter. Colleagues, I don't think I'm going to allow follow-ups on this matter. Yeah, but I don't think it will assist because you can see what we are dealing with. And this is in front of the people of South Africa, by the way, we're live. Now, DM, I think we might need more conversation about this spot. And I don't think continuing to ask them questions is going to assist anyone. Because I condemned that, or I called him to order when he was saying they are misleading, but it would seem that they were misled back and forth. And I don't think that's the direction we need to take. I think perhaps in as far as answering from the board, we must leave it here now. And then, but let me not suppress Mabena. You had a question, Mabena. My fear is you will still be taken forth. Someone will answer and someone will counter. But let me allow you that opportunity because I have suppressed you way too well.
Hey, Chair, I don't know, like, we are very different today, like, we are definitely, I don't know, maybe I must change the soap that I bath with. Eh? It's different, like, honestly.
You are suppressing me.
I think, yeah. But here is the question. On the issue of vetting again, someone that is acting is not vetted. And then we said also that there is ongoing vetting that is currently happening. Here is my question. If the current vetting process comes back, says A, B, C, D have failed the vetting or their vetting was not successful and they've been acting, they've been exposed to state secrets without a security clearance, who ultimately must take responsibility in terms of that? Because that means you would have exposed the most sensitive information to someone that was not vetted. And the thing that we are saying that there is a vetting that is currently ongoing, and I believe that the vetting also is quite extensive to other executives. So now all of those people, and we've got so many acting chief executives at the C-suite level. And all of those comes back and says, none of these people, I'm not preempting the process, but I'm saying as a risk mitigation strategy at a board level, we spoke about here that there's a regal that is there at board level. What then do we do at that level? Because someone that was acting would not, you might not be necessarily be in a position to even hold them accountable if it comes back to say that they failed the vetting process.
Thanks, Honorable Maben. Honorable Kobe, do you still want to really say something?
Chair, it's just a clarity-seeking question. I think the deputy chairperson said that the acting CEO was appointed on the 27th of May. But Mr. Letswalo was then put on special leave on the 28th of May. So during that 24 hours, did REF then have two CEOs? One acting, one new acting, while Mr. Letswalo was there until he was then given a letter or the instruction that he's on special leave. I think maybe I'm confusing the sequence of events, but if the board could then clarify us. Thanks, Chair.
Chair, if you could come in on these two questions that have been asked. I'm closing it now. Because I think we are becoming a circus now. We are becoming a circus. Please, comrades, colleagues, please, just allow me to lead you now. Just allow me to lead you. Can I just really subordinate you to my chairmanship, please? If you can come in, I've seen you have been agitated from long time ago. You're raising your hand. I'll only allow you and allow the chair, and I'll close on you guys. And perhaps I'll even release you.
Yeah, thank you, Chair, and thanks for the opportunity, I guess, to allow me to speak. I think before I speak, one has to confirm that sometimes it's quite hard and difficult in some of the circumstances. But Chair, I want to be transparent and share a couple of things. I think of recently from Audit Committee, and I'll bring the issues of risk governance into play. Of recently, I can confirm that we have signed off the annual financial statement for AGSA to audit. We've also signed off the APPs or the APR for the AGSA to audit. There is assurance as well that the internal audit has audited those numbers, and we're comfortable with that. We're now waiting for AGSA to then pronounce in that regard. What that demonstrates is that from a performance point of view, just in terms of the APP, the organization has achieved 85%. When you look at the same number over the last 5 years or so, on average, the organization has achieved 84%.
Without disrupting you, my man, go straight to your point, because that matter has been clarified properly. That you,
the point I'm trying to make, Chair, is that as a chair of Audit Committee and on behalf of the Audit Committee, I think we have also picked up issues around governance failures within the organization, to the extent that in terms of Treasury Regulation 3.1.1.15, we have actually returned to the ministry around the concerns, because that Treasury regulations allowed us. This is now the Audit Committee. I just wanted to be transparent and put it before the committee that...
What are the issues you are raising there?
Chair, the letter has been submitted. It has been acknowledged. I don't want to disrespect the ministry. In there, PCOT has been cited. I would respect that you get that letter at that point in time, if the chair allows. But there are
PCOT is cited. You are saying the PCOT is cited in the letter?
the PCOT was cited, or an issue that impacted PCOT is highlighted in there.
No. Hi. DM, do you have this letter that the audit is speaking about?
Chair, the letter, I learned about the letter yesterday, Chair. And secondly, Chair, let me say this. I want to indicate this, Chair, when I speak about the ecosystem, and make an example and say the Department of Safety and Security here in the Western Cape gets a clean audit. But if you look at the elements and areas of crime within the Western Cape, you see the challenge that we have. And so the context in which we say we're looking at the whole ecosystem is inclusive but not limited to impact of what those audit outcomes and assessments do. Now, what you're going to have yourself settled with here, Chair, as an observation, there is a tendency, Adre, for everybody to try and prove themselves right and everybody else wrong. And then it becomes a... And so I'm asking you, Chair, to just to beg your indulgence on this matter of Concord, to ask the Chair to respond. Maybe put it differently, why didn't she sign the papers?
Look, I've already requested the Chair to come in. I think there are 3 issues that she must come in on. There are follow-up questions by both Honorable Ghana and Honorable Mabena, and the very issue that has been claims and counterclaim. Kubeka, can I just suppress you and I close it at that? I think we must release this board now. After the response by the Chair, I'll give you direction on what must happen. You'll have to come closer when we're done with the board. Members have some few questions to you, directly to you, that we may want you to clarify. Yeah. Not now. Let them respond, and then we'll then take a decision on how we move forward with them. Yeah. Chair?
Thank you very much, Chair. Regarding the matter of the AGSA, okay, let me just explain the decision-making process. The decisions of the board are taken by consensus, majority consensus. And then afterwards, there would be board members who dissent and placed on record or disagree. But also the process allows for a member to, if there were issues that were raised unresolved in the process, they can, subsequent to the discussion before the implementation of the decision, express, because we professionals, they are allowed to express their disagreements if they're material. So regarding this matter, the decision of the board, the consensus was reached in the meeting regarding this matter. But there were questions that I raised that were not answered in the meeting. So I decided not to disrupt the decision-making process because obviously the consensus was reached. But subsequent to that, I wrote a very detailed letter stating that I'm in disagreement with the decision because there's certain fundamental questions that were not answered. So the board called a special meeting, and in fact, before the signing of the Concord papers, I made sure I actually requested a sitting to go through those unanswered questions so that they can satisfy me as a chair of the board, because I had a fiduciary duty to sign this, and I couldn't sign in principle if there were fundamental disagreements and unanswered questions. That would be a deal breaker in terms of my fiduciary duty as a board member, and secondly, as a chairperson. Can I finish? And after that, they went through. Can I just explain, Chair?
No. Honorable Kobe,
So the meeting was taken. There was a special meeting to consider my concerns. But instead of considering my concerns, the meeting turned into taking a decision to appoint the CEO to sign, because clearly I couldn't sign. I did make it clear to the board members that if my questions are answered, I won't be able to sign because I'm not comfortable with the decision. So that's what happened, Chair. Then I didn't sign.
There was a question relating to vetting, to vet act member. That was the question, Honorable Ghana, right?
Okay.
Yes, it was. So I'm saying there seems to have been, and this continues, that people are appointed in acting positions. Because if they are acting, then there's no need for vetting, because you're appointed today. I guess on the 27th, when you're at the board, the acting CEO didn't know that it's going to be the acting CEO. In the evening, it was the acting CEO. So there are no checks and balances. That's why you are sitting with the case of the acting CIO that you had to suspend from an acting capacity, because was just taken in like, appointed, I know, come, China, come. you are appointed.
No, thanks, Honorable Khan. Yeah, that.
Chair, the positions that the board influences in terms of our delegated authorities are executive positions. And all those positions, they're supposed to have gone through the vetting process. So when you actually ask somebody to act in a position that is parallel, you would expect that all the due processes have gone through. I'm just talking about in principle. And then the lower part, obviously, the CEO appoints acting incumbents in that process. We were, and we still accept that, we were sitting with a long list of vetting executives that hasn't gone through the vetting process. And we were basically told that the process is outside our control. And yes, we do accept that the SSA actually execute that process as long as all the members that are expected to be vetted have submitted their documents. But what has happened currently now with the CEO, that the acting CEO, he's an executive. He shouldn't have been gone through that process of being vetted or in the process of being vetted, basically. So you're not taking somebody at a lower level who hasn't been submitted to the vetting process to actually act at a higher position. But the lower level staff, then the executives actually appoint the executive. But it has been a concern to us that the vetting is an issue in this organization. But there are dependencies in the sense that there's certain areas of it that are outside of their control. And also we've been assured that the MIE integrity vetting process, that includes criminal checks, takes place before all the senior members go through, get appointed in terms of the appointments process. So yeah, no, but that's my answer, Chair. I don't know if there's another question.
No, it's fine. I think let's leave it, colleagues. We will never get sufficient answers. I think we must concede to that. You have a question for the chair. Let's hear the question for the chair.
Chair, my question
You
is...
want to interrogate me in front of our colleagues from the department?
No, Chair, I think now this is more a governance question for you. That if the board takes a decision and the chair or anyone else in that board refuses to implement that decision, does that not constitute insubordination? Thank you, Chair.
Yeah, thanks very much, colleagues. Colleagues, you will never get answers. It's clear, because you will get an answer, someone is going to contradict that answer. So it's not necessary, colleagues. I know, Honorable Montana, you are bending, you are itching, but I think we need to make this determination. Honorable Skwamba.
Can I just put one sentence to you, not to the team, Chair? Because
it's proposal from my side.
Chair, let me say in one sentence, because he's talking about governance. But I don't think that the issue the Chair is answering, it has to do actually with the very existence of the REF in terms of the financial implications, the impact on the financial statements of this company. So this standard issue is not a small issue. It has to do with the very existence.
Yeah, thanks, Honorable. Yeah, thanks, Honorable Montana. Shukwamban.
Chair, mine is just a proposal because I can see that bad things are happening here at RAF. There's genocide here at RAF. So
that's a big word.
Yeah, and then now I want to suggest, Chair, because I overheard your comment that you are actually pushing or you are forced to chase these people so that we can have Mr. Litswalo alone so that we can ask him questions alone. But I want to propose that let's rather ask Mr. Litswalo questions in their presence so that they can lie while he's here.
No, colleagues, the chair has never been inefficient or ineffective in terms of guiding this.
No, I'm not suggesting that.
I note your concern, yes, but allow me to rule.
Thank you.
This is what's going to happen. We are not here to conduct a tribunal. We are here on fact-finding process. Therefore, we're going to have our own session with Mr. Zwa. What has assisted is that he would have heard everything that was said here, that in case you are to ask him, he will still exercise his right, by the way, on matters that he feels that are sub judice, he may not want to divulge here, just like they did. But I don't want to create a situation as if we are pitting the other against the other. That's not our responsibility. Our responsibility is to get information from Mr. Tola. I think I must clarify that to record. So we're going to afford that opportunity. I need to take this opportunity to thank the DM for having created an opportunity for these colleagues to come here and account. Had you not brought on debriefing, you have always indicated to me that there are challenges at RAF, but I don't think we have ever imagined that the extent of challenges is what we are dealing with now. I must be blank and honest. Where I'm seated, it may not be in my terrain, it may not be my province to make that type of a judgment. But there's a total governance collapse in RAF. At least at that level. I'm convinced. I don't want anyone to convince me again. There is, to the extent that even the DM acknowledges that they are what would use the phrase of factions at the governance level, it's a problem. And I really wonder to what extent that you even subscribe to the King's Corporate Report, the King's Code. I don't think you are even closer to that. But look, we appreciate the fact that you came. To the extent you could, you did answer. And to the extent you could contradict each other, you did. So that any other pronouncement we make from our side, it will not be a prejudice in whatever way. DM, like we've said from the beginning, we appreciate that, and that this is happening live when the people of South Africa are watching, so that they know exactly what they are dealing with, so that we are not seen to be sweeping other issues under the carpet and so forth. And the interventions that continuously you made assisted us also to open our thinking and our minds to see what is actually happening. We appreciate your honesty to say you have written a letter that cites us. We are going to request to see that letter. Formally, we are requesting formally that particular letter, that we need to see that letter where you are citing the PCOT in your writing relating to matters relating to governance. DM, I'm going to release you and the team. We appreciate it has been a long night. We'll remain for an hour with Mr. Lutswalo to have our own interaction with him. And then from there, we'll then communicate with you of what we think should be, from our side, the way forward. If you could say a parting shot.
Chairperson, I want to thank the Portfolio Committee. I see that Honorable Montana's out, just on the very important point that he raised as a one-liner, to say to him that obviously there is consequence to the issues around the Concord, and hence the 21 days for an impact assessment to be done. And to reiterate what I said in this meeting, that we need to find a responsible way and manner in which we can deal with that particular matter, and hence the urgent need to engage with the ASB to indicate on this matter, which I'm meeting tomorrow. And then lastly, Chair, is this. The challenges which we are currently experiencing at REF obviously require a collective effort from all of us. And earlier on, I said I met with the board and the executives yesterday. In that meeting, I said, so that the committee can take comfort, we are here ukuzovulelana ifuba. to point to where the challenges are, with a view to then take informed decisions about the future and direction of REF. So it's a classic example of what the problem has happened now, that can you not characterize the fact that the chairperson of the board says she will not sign the papers as dissent, right? But what happened in this meeting when I said that? There was a direct contradiction from the executive. That's not what happened. Just before you hear, just now. Because I don't know what else it is. When the chairperson of a board dissents, and then you want to contradict me here. So it goes to the heart upon which REF continues to present information. And I'm just wanting to issue a warning to the executives in your presence. Disabuse yourselves of this tendency. And Chair, as I've said, we have met yesterday, and we are going to apply our minds objectively in the interests of the RAF for the entire ecosystem, and come back to you with a concrete set of recommendations and the way forward. So I want to thank you very much, Chair, for this opportunity, because a part of me had assumed that after yesterday, we had all seen and taken time to reflect on the issues that were raised. I'm seated here convinced that that did not happen. There's a hardened attitude to continue on a path which I can only summarize around what Ms. Trunchbull says in the Matilda movie. I'm right, you wrong. I'm big, you small, and there's nothing you can do about it. That is the attitude at REF. To the board and to the executives. Shape up or ship out. And we will come back to you, Chair, because REF cannot continue on this direction. And so when the Honorable Malma just says it's embarrassing, he's correct. He's absolutely correct. And I apologize to the committee that you had to be subjected to this. This is not what a professional entity with a professional board and professional executives should be conducting themselves in a parliamentary engagement. And it's the last time, Chair, that such will happen. Thank you.
Thank you very much. That was your parting shot, DM. Just to concede that in my almost 10 years of involvement in legislative work, I've never faced this type of a sarcasm. I've never faced this type of, which I could touch and smell a sense of dishonesty. I've never had that experience, but it is what it is. It's a trajectory that we have to traverse. It's a uncharted route that we'll have to charter. Thanks very much. Have a great night. We'll communicate you very soon. And there are certain information that we may need, including that letter, including the minutes relating to the Concord. No, I think acting DG thought I'm done. Acting DG, I'm not done. I apologize to the meeting. We are not done. Yeah. I don't think you did it purposefully with intention to undermine the committee. But I think, colleagues, without wasting your time, go home, go and sleep. As part of sleeping, kindly reflect surely on your conduct today. Just take time in your own 2 minutes in your own corner. Ask yourself hard questions about what you are doing. There are more than thousand beneficiaries, by the way, DM, who are watching this with a sense that maybe they are going to be getting something that is helpful. But thanks very much. Have a great night. We are going to break just for 5 minutes so that you can allow them to go in. And if you can sit when you come, no, DM, you can go out. If you can come closer, so that you can come and sit here. The honorable members who have questions for you, there are those who don't have questions for you. Feel free to stand up and go, no matter what.
Chair, maybe I would plead that maybe we could give the CEO maybe 5 or 10 minutes for him to say his piece. Yes, a lot of things have been said. We can give him 5 minutes for him to say his piece, and then we'll then engage him after that. Yeah, whatever you Chair will discuss. But I'm just saying maybe we could give him that opportunity, let him plead, and then we can. So that's because as we are going to take him to a particular direction, only to find that maybe in his mindset there's also something that he wants to express. So let's give him that 5 minutes, and then we'll then engage him.
Thanks for that. I'm going to guide as follows. That is why, firstly, I want to plead with you, colleagues. We have been here the whole night. Would have jointly seen the circus that was happening before us. Undesirable as it is, we have more facts now and we know what is happening, but we'll still allow him to give his side of the story. He'll sift what he thinks he must sift. And and then from there you'll ask questions where you must ask. Those that bother us on certain things, you'll have not to ask them, and I trust you not to do that. I've not earlier on acknowledged the two gentlemen at the back, Gernel and Mwako. Motlhalog. Yeah. They usually attend our committees as interested parties. I was not aware, Gernel, that when they speak about Gernel in draft, they are talking about you. Now at least I understand you are an interested party in the real sense of the developments. So it's in your right to attend. You are protected by the laws to attend and listen to the developments where you have interest as a South African citizen. So feel comfortable, yeah. Even those who are following, there are a lot who are following from home now. Are we on now? Yes. Colleagues, thanks very much. We are starting now. Maybe to give you a background, that we have invited you here as a sequel to the meeting that we would have had on the 3rd. When we met with your board, led by the DM, the Honorable the Deputy Minister, on the 3rd, we're meeting on the basis that we wanted a brief because it was all over the media that you are on special leave. Fortunately or unfortunately, whatever the appropriate word will be, was that on the day when we met the board, on that morning, we also learned then that you are now on suspension. And in relation to that, we then asked questions to the board which were not getting answers. We did not get sufficient answers from the board. Hence, we then requested that we may need to have more of engagement with them, and we requested that the only opportunity for them to come is today. We also had to then invite you because certain things for members to formulate their views and position, they may want to hear a certain side of the story from your side. I must indicate that that decision to invite you put us in a dilemma. And we had to get a legal opinion whether we can invite, and I must say this on record so that it's captured, whether we could invite someone who's suspended to come and appear before us to get further information from that individual. And I think we got advice that if that is in pursuant in assistance of getting to understand more and to assist us to continue our oversight work, and that will be helpful and enriching. It is therefore within our right and within the law that we can do that. So it is on the basis that you are here. We also learned yesterday that you had filed your papers with the court. I don't know whether it's the High Court. I'm told it's the High Court. That you want to challenge certain aspects. We do not have merits at this particular point. You would have been here, you would have heard, we do not have merits of what we are challenging or not challenging. But we know that is in relation to your suspension. We may not want you to go into that. We are not taking you to court on what you are challenging, how you are challenging it. The merits is up to you to decide what you want to tell us, what you want it to be in the public, and what you do not want. But for our reports, there are specific answers we would want from yourself. And these honorable members who are here from various political party divides are interested in understanding from your side certain issues relating to the operation of the entity, which is of great interest to the people of South Africa, because there are a lot of complaints about unpaid claims and so forth. We only hear today that with the CIO, there are challenges with the CIO, who's also now suspended and all that. We would want you to take us into confidence so that as a citizen of South Africa who wants to help this committee to achieve its oversight responsibility, we trust you can do that. I'm going to allow you an opportunity to reflect. We'll give you 5 minutes, 5 minutes summatively to take us through. From there, honorable members will be given 3 minutes each to ask you questions, and then you'll answer, then we'll close. I think that will be sufficient. We must appreciate the fact that you came. The secretary did indicate to me yesterday that you had a challenge in relation to the approvals of your travels because of the existing issues with the board and so forth. That is noted. We appreciate the fact that you're able to arrive. I'm going to allow you an opportunity, and over to you.
No, thanks very much, Chair. Thank you very much to honorable members. I don't take it for granted, the opportunity I get. I must say a lot of South Africans that find themselves in my position never really get the opportunity to air their side of the story, and I think it's important. I don't think that it's only important to me, I think it's important to my family. It's important to my kids. It's important to my father, who is not doing very well. And this thing keeps on happening to me, Chair. I don't know what I've done to South Africa. But I'm going to explain this thing because it is not for the first time, Chair, I appear in front of PCOT. Last time I appeared under the same guise was at Prasa, where I was accused of having paid myself 350%. And it was shocking that someone can say it's the first time in the history and all that, because that's not true. But I think what becomes important, Chair, I think one is that I'm being muzzled, and you'd see it with the continuous decisions that are taken. I'm being muzzled because I'm vocal about a couple of matters. But let's start firstly here, Chair. I came here with the money of my children. Yeah. I have booked myself in because apparently I can't fly. I don't know whether I'm fired or not, to come to honor an invitation by PCOT. You would recall, Chair, that I am on suspension because apparently I refused to come to Scopa. Now, I don't know whether I was supposed to not come also to PCOT when PCOT invites me. I've returned to the Chair, and I think I've given to the Secretariat of your committee the response I got, that I must not be here. In fact, I might just be charged again for insubordination because one of the conditions is that I must be in Gauteng. I must be in Gauteng. I must not leave Gauteng. I must be in Gauteng. So I am actually breaching that condition by honoring your invite. So I hope I'll get the protection I need in that regard, because I might just wake up and find myself with this. Chair, there's no crisis at the RAF. You say it's a circus. There's no crisis at the RAF. It's man-made. It starts because of my appointment, and I'm going to give you a sense of what's happening. And I'm going to show you that we have achieved what we have achieved in spite of the lack of support from the executive authority or the department. Let me just say the department, because I think it's in the main. And I hasten to add this because when you say these things, people make it personal. The reality is this, and I think much as the Deputy Minister was allowed to say things, I'm sure I'm allowed to say this thing, Chair, that the Deputy Minister has taken off from his time at Scopa to continue with, I don't think it's even personal, it's a thing he has against the RAF. And I'm gonna show you through this process. So we have a draft amendment bill. It is in the department, it has not moved. I think since 2022. We've got a funeral benefits cap memo that we wanted to get in terms of section, I think it's 11 of the RAF Act. The board is allowed to advise the minister on matters concerning regulations. It's there in terms of the act. I think I must just give you the provision. I think it's 11.4. I'll be correct, Chair. 11.1A, Roman figure 5, which says the board shall, subject to the powers of the minister, exercise overall authority over the financial position, operation, and management of the fund, and may inter alia, A, make recommendation to the minister in respect of, it says, any regulation to be made under this act. So we do that. There is an actuarial calculator that has been put in there because what we are finding is that a lot of money goes to a thing called the general damages. We don't know what that is. A lot of lawyers would go and say a lot of things and then we're paying money and it's something that is not understood. And then, of course, there is issues around appointment of board members. There is a representative of the board that comes from the department. They don't tell you that they appointed that person, I think, this Monday. Before then, since the former representative left, they have not appointed any person. And of course, then there is issues around the reappointment, which I'll come to. And then I'm going to tell you about the SIU, because I think it becomes important that when you deal about this issue, Chair, you think about this issue about the SIU and what had happened in this regard. So all these things are stuck in the Department of Transport, and they have not gone anywhere. We've been asking for them to come, they have not. In fact, the only thing that they did is that we received a letter from the Deputy Minister talking about the withdrawal of the draft amendment bill. Those that pride themselves with stopping this had told us that this thing will be withdrawn. And indeed it was withdrawn. Replaced with what? The so-called RAPS bill, which failed in Parliament. But we have never got anything like a gazette that says it was withdrawn. It's a letter like that. And when we asked, we were told we'll have a meeting. Then, of course, the next part is you then have you'd have received our strategic plan of 2025-2030. And I want to invite you to read page 2 there of what the minister says. The minister says we'll continue with the draft amendment bill. Remember, we were told it was withdrawn, but the minister says we'll continue with it. And I think the DM keeps on calling, going back and saying, well, there is the RAPS bill. What is happening here? At the center of this is the soul of the RAF that needs to be captured by certain individuals. And it has taken some form. And you see this board going all over. And Chair, it's because they are scared. They are fearful. They've been threatened. They are acting out of character simply because they've been threatened. So they've been divided. Because they have held the fort. 84.5% performance in an organization where you don't get a cent. Okay? Go to SAA. They received money. Go to Transnet. They received money. Go to PRASA. They received money. Go to South African Post Office. They received money for their turnaround. The turnaround of RAF has never got a single cent. And that's a fact. So, that's a fact. So, what do they then do? Then, there are those that we found in the RAF. People that used to get 1.2 billion a year. In fact, at the time, when we started this work, Michael Brolio said to me, the lowest amount I got was only 65 million a month. He used to get, Adams and Adams used to get 100 million a month. Those were called fixed allocations. How did they happen, Chair? There was an agreement with certain law firms. Big as they are, and people are going to say I'm making it about black and white. Check them. If they are white or black, go and check them, the top 20. They used to get 1.2 billion each and every year at the top, which is Adams and Adams, Hartnell and Associates, De Broglie and all the others. What did they do? They used to take that money allocated to their clients. We changed that. We said the oldest debt first. It doesn't matter whether you come from Makotlangu Incorporated at the corner, but the oldest debt first. At the time, which is going to explain the issue of Mr. Mudiba, you'll see it. At the time, those law firms in the top 20 had probably 30 days. There were law firms that were sitting with 1,800 days of debt. So we came as finance people, we said we must stratify this debt. And I think Mr. Mudiba was at the center of it, to stratify the debt. What did it do? We stopped payment to the ones that were 30 days, and we were saying all of them must come closer, and then we agreed on 180 days. We went to court, we asked for 45A to support that, to suspend certain court orders until 180 days. Hell broke loose. Because suddenly, these law firms that used to make a lot of money out of RAF did not make it. And we got on. As we get on, people just put the pressure, they piled the pressure, they piled the pressure. And they piled the pressure on the board chair. It's painful to watch this board made up of seasoned professionals. The chairperson of the audit committee is an actuary. Okay? There are doctors in here. They are serious people. So, decisions are taken. So, when did this sudden disconnect happen? And where people try to throw each other under the bus? And I want to settle, Chair, because I want to allow you guys to ask questions. When did this happen? So, somewhere in November last year, I pick up that certain law firms have hired a company called Communicate. And these law firms were going to use, and I've said this in public, Chair, so I'm going to repeat it again, certain professors, one of them being Henny Klopper, but other professors as well, to try and put this mounting campaign about Letsoalo and the fact that he must never see his way back into the RAF. And I pick it up, I raise it, and I know certain editors also met, but I know their names, and I told them, I said, well, sue me if you are saying all that. And I've been threatened with being sued, but I'm not worried, because, you must come under oath, and I've got that information. So they start this campaign. Then it takes the form of attacking the board, trying to separate me from the board, isolate me, do a couple of things. We discussed this with the board. We agree this is the direction we must go and we must keep on. So this had started, Chair, a long time ago, but it was before the hiring of this
as
company.
you summarize.
Yes.
Yeah.
So then suddenly I get a call from the chair somewhere around February that says I had just had a meeting with the deputy minister. He is of the view, and she raised this issue that the AXA CEO's position was not advertised. And that that creates issues, and the preference of the ministries that the position must be advertised. My position. So I say, but Chair, what was the nature of this meeting? And what were you discussing? And who called it? And what was the thing? But in any event, you are talking to me, I'm conflicted because in my view, I still want to stand a chance whether you go to advertise or whatever the board decision would be. Then this apparently went to the board. Of course, when they discussed those matters, I recused myself because I'm conflicted. But that's what it happened. So this instruction to go and advertise started long before. It goes to the board, and apparently it does not find favor. And how do I get to know about it is because then I'm asked to go and write a 360. This 360 comes as a decision of the ministry in August last year, I think. Yeah, in August last year, we were called, all of us, and we were told there is a thing called reappointment of CEO. And if there's a reappointment that is required, Chair. Yeah, by the way, there are CEOs there that they're on their third term at the Department of Transport. And they said, if you want that, you must bring this and the 360. That's how I got. So my 360 ends on the 14th of May. Chair. I did my 360 on the 14th of May, meaning there was a decision to reappoint. So then what also happens in this space is that we are now pushed at Scopa. This thing, come. And there's an SIU thing. So we receive a letter. It's a strange letter that says there is some sort of interference, but it comes from the minister. There is some sort of interference. Please warn executives if they are. We say, look, what is this now? But it came after the meeting of the 25th of April, where I think it's in this very room where Scopa was, or whether it was online, but it was where the SIU had been saying things, disparaging things. And I had been engaging them, by the way, and that they are not allowed, they are not working according to this, and then this is what happens. But Chair, they must tell you that yesterday, the DM said to them, there shall never be any letter that comes here that talks about reappointment. He instructed the board. And yesterday they went and discussed also about the fact that they made a mistake by not adding this thing of the SIU in my letter. But they're saying this in front of executives. Of course they were going to tell me. So they are aware of this thing. So the pressure is coming from the ministry, Chair, led by the deputy minister. There's no question about it. He can say that. I'll tell him the number of letters. Every other week we receive a letter at the RAF. We must respond to it. You must ask them the number of special meetings they had to hold because they've taken a decision. Somehow it went out of the board and the DM is aware of it. Then suddenly a letter comes that says, why are you deciding this? Why are you deciding that? So, Chair, is it true that there is interference at the RAF? So this thing is trying to create a whirlwind where this thing must just be seen as this mini mess. There is no state entity or any entity, Chair, that can perform consistently at the rate average 85% over 5 years that is in this mess. So there's no mess here. The difficulty, Chair, of the other members is that they can't raise their hands, they can't say it. I thought today they'll be given an opportunity, Chair. They must tell you what's happening in there. I'm happy that you'll go and to get the letter that comes from the audit committee. I'm sure it will raise issues. Lastly, Chair, there are just lies that have been told. It's not misrepresentation. So, one is that you are told I received my letter before they came here on the 3rd. No. I received my
Let's not say lies, let's say misleading information for our sake.
Okay, Chair.
Yeah, for the sake of our record.
It's fine, Chair. Can I be allowed to use a fib? Is it a fib?
No, just use misleading information.
Okay. So, there's disinformation, misinformation, and all that. My letter I received on the 25th, 9:25. I was watching. As my suspension was there, everyone in South Africa was seeing it. My children are seeing it for the first time. I've not even spoken to them. There it is. My wife sees this. She calls me, what's going on? I'm like, love, I don't know. All right? The suspension of Mr. Modiba, the very same thing, Chair. All right? But, Chair, I want to touch on one aspect. I'm going to deal with that. But, yeah, as I conclude, because then there is a story about the 27th, the 28th. No, I was coming here. In fact, I can give you tapes of what the chair says. Apparently, this thing was about to be compassionate leave. She was supposed to talk to me as the chairperson, and suddenly this is a decision that is taken to place me on special leave. That was not a board decision, Chair, I can assure you. So now, every time these other board members raise issues, they are then muzzled. So I come here, I fly on the 27th at night. They know that I'm flying at a 9 o'clock flight. Then at 10 to 11 at night is then that I receive my... No one even says, check your email, nothing. As I'm preparing to come to Scopa at around 7, I wake up, I check. Oh, I see this thing. It's even telling me who's going to act on my behalf. Of course, I call the part 2 and I say, part 2 take over, and he's resisting. No, I can't go there without you. No, go, man. It's fine. Because the aim was that if I come here, then I'll be insubordinating. If I came here, Chair, I would be insubordinating the letter that placed me on an unlawful special leave. Okay? So I decided to stay in the hotel. I watched this whole drama at the hotel. I had the chair sitting here adding reasons for my special leave, which were not even in the letter. But then, fast track, the next day, Chair, they were, as I conclude, they were at all these things they are doing now, suspending this person, doing this, and ultimately they want to remove part 2 as well. The aim was, they went there, the REMCO chairperson, the deputy chair and the chair went into RAF offices. Fortunately for us, someone was sitting next door and listened to everything they were saying. It was to suspend me, suspend Sefutle, suspend Mambi, Kumalo, remove Mpomanyasha back to her position, put part 2 is malleable, they can do whatever they want to control him, and then appoint certain people. In that meeting, they were calling people that were below us. Come here, tell us about this. We want to appoint you in that position and all that. That's what they will be doing the next day after the 28th. I wrote them a letter on the 30th because they had said that my special conditions were going to be discussed by the 30th, and they didn't. And they did not bring it to the attention of the board. Notwithstanding the fact that they had told me. When I realized it, that Saturday on the 31st, I sent them a letter. And in it, they were saying a lot of other things. You'll see it in my papers, Chair. It's attached there. But, Chair, I'm sitting here. The chair has arrived here with her bodyguards. They've taken away my security. I flew alone. There were people that tried to kill me twice, and they know it. And that's why I've got security. Today, I'm for the taking, Chair. And they made sure. And for me, Chair, let me say this as I conclude.
Yeah, conclude.
I'm prepared to die, Chair, for the truth. I am prepared to die for taking on the likes of Discovery, the likes of Bonitas, the likes of Gertnel and Associate, the likes of any other person in the interest of South Africans. This 50 billion that we talk about was going into those hands. Today it's sitting in the hands of South Africans, and I'm proud of it. Anything that happens to me, Chair, I'm not a coward. I've never been brought up like that. And for me, it's fine.
Thank you.
Thanks, Chair.
Thank you very much. Honorable members, I'm going to allow you, I think the information to a great extent is sufficient. If you may say you are not answered, but I'll allow you opportunity to raise straight, no background, colleagues, straight to the point, questions, and then he responds, we close. Montana, let's start there.
Thanks, Chair. I think I'll be very brief. Number one, Chair, let's start. Let me ask the question about, you asked the question about, on the third, that when when the deputy chair of the board spoke about the legal advice and the change to a from what is called special leave to a suspension. When was Mr. Letwalo given notice? Because you were given an assurance that he has already been served. So when we met, that's the first question. The second issue, did the letter of suspension ask him to provide reasons? Ask him to provide reasons within certain period of why he shouldn't be suspended. That's the second issue. Thirdly, Chair, I want to know in terms of the legal fees that we are talking about. I think the board mentioned earlier on that they have this milestone of 50 billion rands that has never been done before in terms of putting that money in the hands of claimants. That's what the chair says. And I think that you presented to, when we were at the ref, you presented about the growth in that claims thing, and what you think the trend is. And finally, Chair, I think what I want to ask is the support that the ref, because I heard you talking that there are all this, the bill is there, amendment, the Ref Amendment Act and everything is sitting at the DOT, the advice that the board should be giving. What support has the DOT given to the entity during this entire period? I think when the board was trying to make, or rather the board and management was trying to make all these changes, did you get support? Did you meet with the minister? Or did you meet separately with the deputy minister on behalf of the minister? I think for me that will give me a sense of the support that you get. Thank you, Chair.
Thank you very much. Quebec, straight to the point.
Yo. Thanks, Chair. Chair, the acting CEO spoke of a saving of 50 billion rands. Or not a saving, he said there was 50 billion rands that was paid to claimants. Now, the money that was saved there, I wanted to ask the CEO, that's the first question, where did that money go? What was, or where did they get that money? Where was the saving coming from? I don't know if I'm making sense, Chair. Okay, that's one. And then I wanted to ask the board chair, but you said I must hold it with those questions. Now, I'm not even sure if it's the correct person is the former CEO to ask this question. The question is, when the initial decision to suspend you was taken by the board, do you know if that was a full sitting of the board or not? And if it wasn't, who was there and who was not there? The next question, did the board approve the lease agreement with Moana, the lease agreement which basically constitutes bulk of the issues that started this whole interrogation and this whole issue with the CEO? or was that decision taken by you as the CEO alone? I think, Chair, the problem that we've got here is we've got the APP for performance at RAF sitting at 85%, with 50 billion rand paid to claimants. And then we are told that RAF is in chaos. RAF is in a bad place, bad space. But I'm inclined to now start believing the former CEO when he says this is deliberately created. So the question then would be, who are these vultures that are trying to capture RAF? Because there are vultures that are clearly, from what is just said now, and from the circus that we watched earlier, that are trying to destabilize RAF, that are trying to make sure that RAF is ungovernable, that are trying to make sure that they remove the board, that are trying to make sure that they remove the executive. Now, to the CEO, who are these vultures? CEO, thank you.
Shikomba. No, thank you, Chair. Mine is very few, Mr. Rizal. I want to check. Do you believe that there's corruption within RAF? And if you believe that there's corruption within RAF, what is your attitude towards corruption? And then the other issue that I want to check from you, in terms of governance, do you see RAF being led properly in a manner in which it's actually supposed to be led as an individual, given the years of leadership that we have been from previous companies or departments where you used to work? Do you see RAF being led properly? Just explain in depth the interference of the ministry, because I think I heard you mention something of the interference of the ministry. To what extent? And what does the ministry stand to benefit or want to achieve with the whole thing? And then the other thing that I want to check, it's your security. Every time when I was watching TV the other day, you were interviewed. Half of the time when you get a platform, there's no way you speak and you don't touch the issue of your own security. You're always consistent about security, that you are under threat. There are people who are threatening you. Are you aware of those people? Who are those people? Because, Chair, as I conclude, Chair, yes, as I conclude, Chair, because we may take these things very light, and tomorrow we wake up with someone dead who have been telling us that I'm under threat. So I just want to check, are you aware of the people who are threatening your life? Because if they don't get you as a man, you may protect yourself, but you may not be able to protect your kids or anyone close to you. Who are those people? Thank you very much.
Yeah. Chairperson, briefly, CEO, the question has been asked, but I want to elevate it in terms of support from the department. I think the ministry has in this administration, we've been here for a year now, 12 months. And I asked this on the basis that I've got a letter here from Discovery that was written to the Minister, Barbara. Are you aware of this letter? Did you respond?
Minister Chrissy.
Oh, Minister Barbara Chrissy. Yes. Oh, I'm reading verbatimly here, Chair, so apologies about that. Yes. So this letter, CEO, was written by Discovery to the minister, complaining about you and RAF. And they are even claiming here that your conduct to take them to court It says here, Chair, if I can just read this, if you give me 30 seconds. Discovery Health estimates the loss to the medical scheme industry as a result of RAF and its CEO unlawful conduct. The estimated loss is approximately at 500 million a year. So this is Discovery complaining to the minister that they are going to lose 500 million a year because you are taking them to court. You have won this case subsequent. So I want to find out, what support did you get from the ministry in regarding to this case? And that speaks to the support that you've received.
I know you have a right to information. I may not want to ask where to get the letter between the ministry and Discovery, which...
Chair, Discovery gave it to me. The people at Discovery leaked it. So I want to know if the CEO is aware of this letter. And because the RAF has won the case against us, and is he aware of this letter, that there was a letter from Discovery to the minister complaining about him and the entity, and then what would have happened with that? That's one. And then now, CEO, you are accused of signing the court papers litigating against the AG at Constitutional Court. How did that become? How did you end up signing those papers, and why were you the one who signed those papers? And then 3, you have taken RAF to court because of your suspension. What relief are you seeking there in court, if you are able to give us that brief without actually getting into the matters? And maybe lastly, Chair, obviously now you've briefly touched on the precautionary suspension or the leave, the special leave that you were placed by refusing to attend Scopa. Did you refuse to attend Scopa? What was happening there? If you can just put us into confidence. Thank you very much.
Thanks, Chair. But me, very briefly, because I believe, at least finally, the Portfolio Committee has achieved the objective of having Mr. Letswalo here speak for himself, so that the next time the board comes here and we're to make a determination, it would be out of having a full range of facts. Just for clarity, Mr. Letswalo, for me, I just need to know about the misconduct allegations around the 79 million lease deal. That's I think that's all I want to know. And I mean, when they speak about misconduct vis-a-vis the turnaround of the entity, it gets a little confusing, especially given the letter that Honorable Blosser has just read, that your misconduct is somehow related to unlawful behavior when it comes to sort of cleaning up the entity. Just in your view, do you think that these types of letters and the misconduct that you're accused of is just like really targeted with your against your attempts to sort of clean up the entity? That's all I would really like to know, Chair. Thank you.
Thank you very much. Honorable Ngomban.
Thank you, Honorable Chair. Chair, most of the issues have been touched. It's only 2 now left for me. The first one is that Mr. Letswalo received his the letter of intention or whatever on the 26th of June, if I heard correctly, putting him on compassionate leave, which later changed to special leave, but they committed to call or interact with him on the 30th of May, which they did not communicate. Then you decided to write to them. Were you reminding them of their commitment, or what was the content of the letter that you wrote to them on the 30th? The last one, Chair. After seeing these challenges that RAF is faced with, this instability and, all those kinds of activities that are happening there, which office have you informed about that? And also around your security matters, have you reported to the relevant authorities that may assess the situation and ensure that some security provision is made for you? Thank you, Chair.
Thanks very much. Honorable Ntando Matuna.
No, thanks, Chair. Indeed, it's Honorable Ntando Matuna. No, thanks, Chair. Chair, I will follow suit and be very short. But Chair, I just want to first, perhaps, but I think it's an indulgement that we will have as a committee afterwards. I'm also as well starting to be worried. I'm not saying that the minister is interfering. There's something in auditing that we usually say, you do not have to interfere, but you must be seen to be not interfering. I believe now there is that thing that now that starts to say there might be an interference, but I believe it's a conversation that we might have at a later stage and the reasons as to why. I have a very short questions. Actually, I'm coming to the issue of if you get the timelines. Yeah, Chair. But my first question would be, because I think Mr. Letswalo clarifies me, because my first question would have been around the issue of the special leave. Because, Chair, in South Africa, there's nothing as placing someone on a special leave. Because I was there in scope, and the reasons that would have been given would have been that it's because of issues that are related to SIU investigations and so on. And we told them this. They said to us they had received a legal advice. That today they are saying that they seeked afterwards, because we told them that you can't place someone on special leave. You apply for special leave, then you are given. When someone is interfering on an ongoing investigation, you put that someone on precautionary suspension. We told them this on the 28th of May, I think, when we were sitting with Raf. Now, my first question to Mr. Letswalo, one would be, I think I'm covered by would be around the issue of building. There are allegations, Mr. Letswalo, in the public domain that you went against the recommendations of, I believe it's adjudication and evaluation in the appointment of the building in Joburg, whereby you ended up appointing the building. I think it's the building of the pension fund. That's one. Two, I wanted to check the issue of, because now the reason why Chair, I've been asking this, because I want us to have clarity. I wanted to check as well on the issue of accounting standards with HE that has been ongoing. I believe that this was a decision approved by board. I just want to get that clarity. Two, as well, I want on the issue that when the decision was taken that you are going to act as Chief Claims Office, it was board aware of this decision, and I think Chair will say if he's not comfortable of answering certain things. Was board aware of this decision? Because were they aware of this decision? Also, Chair, I think the last question that I would have had would have been the issue of the building, or the issue of default judgment. There's an issue of default judgments in courts whereby you are supposed to be using the what is this legal aid, but look to state, yes. Yes. Now, though we are told that they go to court and say that they just came here to just observe, not to represent. But can you give clarity to that? And it's estimated that the default judgment that we have accumulated are close to 4 billion. So can we get clarity on that? I'm asking these questions, Chair, so that also the public gets clarity in terms of what is happening, where are we. I know we'll engage alone on the committee, and then we take a decision in terms of how we move forward. I thank you, Chair.
Thanks very much, Honorable Maduna. Honorable Malmaja.
No, thanks, Chair. Thanks, Mr. Letswalo, for availing yourself. Just 3 questions. One, after realizing that you are not safe in terms of the threat that you are getting, have you made some efforts to notify the relevant authorities so to be safe? Because indeed, we will want you to live longer, so to assist to give more information when we deal with the whole issue. The other issue is on your relationship with the ministry, the chairperson of the board, the entire board. Why this? We really want to have a situation where we know the relationship of the CEOs and the ministers, the deputies, and everybody, not just around yourself alone, even other entities, because we will really need, as the portfolio committee, to ensure that there is a good relationship. Otherwise, we'll find ourselves having to cut and chop endlessly. The other issue, Mr. Letswalo, on this issue of lease, is there a reason why RAF, with such monies that is going out left and right, back to center, cannot just acquire a land and have its own properties, rather to be leasing so much, if not huge, millions going out? Is there or are reasons why this cannot happen? Even under your leadership, decisive as you are, but I don't see any attempt of saying at some stage we wanted to have our own land so that we can have our own offices and save this money of the claimants. Because if we continue leasing this way, I don't think we're doing justice to what's supposed to happen. Chair, I think those, maybe to add this one of the SIU, you said and you promised here that you will go deep by bit in it so that we know it's like it's an elephant that we can't know whether it's moving or not. Thank you, Chair.
Thanks very much. Just 1 or 2 from me. The claims officer, it is alleged that you acted for a long time as a claims officer, and the board was not comfortable with that in terms of the reports we're getting. Why did it take so long to appoint a claims officer? Because the claims are at the center of RAF's business. Now, why did it take so long? Especially with the background that we hear now that the board was actually not happy with you being the claims officer. I also aware of the particular matter that the claims officer was not, the board was not happy with that, to that effect. We met with you, Mr. Letswalo, and your board sometime last year in October in your offices, in which meeting all of you projected a sense of united approach to almost all the issues and challenges you're faced with, including the processes thereof that you're actually undergoing at that particular time. We did not get this sense at that particular time of that you are making now of ministerial, the DM, what do you call it? Interference. We also didn't know at that time that the ministry has not appointed a shareholder rep into your board. And these matters did not emerge in that particular meeting, unless I would have missed it, but I went back to check my record today. These issues were not actually there. You are united as executive and as management in terms of your present. What happened? What? I know you would have said there are pressures and so forth, but one would want to really get a sense. At what point what was the straw that would have broken the camel's back? What would have created this that seems like a very serious dysfunctionality and instability, which borders on the eyes of the public? My last question is, day in, day out, we're undated with a lot of people complaining about non-payments and so forth. And I could even see on social channels now that there are a lot of people who want to ask questions relating to their claimants and so forth. What is the status of claims in your own understanding? And what are the bottlenecks in terms of payments for those who might have been awarded in courts and so forth but not been paid? If you could assist me with that, I'm safe in my part. Kindly, as much as you must be depth, but try to be as summative as possible.
Yeah. Okay. Thanks, Chair. Honorable Montana, I received my letter at 9:25 a.m., which was about 55 minutes into the meeting, your meeting of the 3rd of June. At 9:28, 9:25, meaning it's about 55 minutes after the meeting started, with a withdrawal letter that was signed at 9:47, and a withdrawal and a suspension letter that was signed at 9:51, well into the meeting. So, signed by the chair of the board. At 9:27, I received a phone call from the chair, and I did not answer because I was watching. And at 9:28, I received this SMS. It says, "Dear CEO, kindly note there are communication for your attention from the board in your inbox. Regards, Chairperson." I then respond because I didn't see it until later. When I checked my SMS, it was there. Then I answered at 9:48, and I said, "Dear Chairperson, I thought you were not available and had prior commitments. Nevertheless, I'll check my inbox once I've finished watching the PCOT meeting." Her response at 9:50 says, "Dear CEO, yes, I'm committed currently, but I'm able to discharge important things via phone. Kind regards." Then she tries to call me again, and she keeps on calling. So I said to her, "Excuse me, Chairperson, for legal reasons and the fact that our conversations are usually distorted, I would prefer that our conversation for now be reduced to in writing. My apologies. I just think it will be prudent at this stage." That I sent at 9:52. Now, it's up to you, Chair. The deputy chair sat there and said we gave him his letter before we came here. That is not true. So that's when I received my letter. So this support, Chair, I've worked at the Department of Transport for 10 years. I think 11 years as a CFO. I know the support we give to entities. It's not something that I know. Honorable Montana would know that when we were doing 2010, we were sitting there with them, asking them what the issues were. AXA would tell you the restructuring of AXA we were involved in. They would tell you, Sandra, even with these e-tolls, we sit and we look at this. And when entities of ours get financial problems, we are very close to them to try and assist them. It doesn't happen to RAF, at least since I've been there. By the way, when I was seconded in 2019 to this establishment, it was because it was collapsing and they were asking for a bailout. That's how I get myself to be there. And I was then appointed by then Minister Mbalula to go and try and turn this thing around. We advise the ministers, they would come to us, they will disagree, we disagree, but I mean, advise people, then either take it or they don't, but they do meet with us. Have we ever met with the minister as the RAF board? No. No, it hasn't happened. Have we ever met with the deputy minister? No. Only once during a, what do they call it? The AGM, the annual general meeting where you bring your, that's a ministerial, it's actually the shareholders meeting, it's not your meeting. We have never met with them. When did the meeting ever happen? Yesterday. And I was not there, Chair. I don't know whether it's a coincidence, but I was not there. This meeting was supposed to actually come and you would see it in each and every meeting of the board. Can Chair please write to the ministry and ask them we want to meet with them? Then the question that lingers in my head is, when people come and say, well, we are going back to the RAPS bill, who's informing them, who's advising them, who's talking to them, how did they arrive at that point? Now, Honorable Gubega asked the question about the 50 billion, how it was saved. 30 billion was in legal fees. 14.5 billion was in medical fees. 4 billion was in payments to foreigners that are not supposed to get the money. And I'm going to come back to this because when we are going to deal with default judgments, you must understand that the Western Cape decision was a rescission. We were rescinding a decision that was taken on default. Now, that's how we make the 50 billion. Of course, there was a panel of actuaries that were charging us 10,000 per calculation. By the way, this medical fees are as a result of this medical, the hospitals and medical practitioners charging us 5 times what they charge a medical fee. As I told you, there are, oh, I did not mention this part. There are tariffs that have been sitting with the ministry for more than 2 years. They've not been signed, those tariffs. And it's something that continues to worry us because when those tariffs are there, it means that they can't be implemented. And soon we'll be told that these tariffs are out of kilter and therefore it's unreasonable to expect people to charge those tariffs. As it happened in the during the Moseneke judgment of 2010, where we were told that we must go back, and I think it was Minister of Transport versus the LSSA, if I'm not mistaken. LSSA versus the Minister of Transport and others, where we were told that we must go and make our own tariffs. It never happened until we started. And I think our tariffs, the first tariffs we issued is in 2021. But for 11 years, that had never been done. So, I see Honorable Gubega keeps on referring me as a former CEO. I would also think so if if someone was taken away and he can't, he can't, yeah. This building, it's a very interesting phenomenon. Firstly, I never rubber stamp anything. It will never happen. The PAC is appointed by me. Although the lower committees might be appointed by someone else. They're appointed to advise me. And when they're appointed to advise me, I can reject their advice. Because ultimately, I can't delegate that accountability. I'm accountable ultimately for everything. I'm responsible for it, even if I gave someone to do it on my behalf. So, what had happened? We were in a building called Marble Towers. Below us, there were lawyers. Above, there were lawyers. You know, there are law firms that run around with logos of RAF on their cars. And that's one of the things I fought when I got there. So when I saw it, I used to write to them, remove that logo. You are not RAF. But they were below and above in Marble Towers. What used to happen is that people that would
What do you mean? So you share a building with lawyers?
Yes, we share the building with lawyers.
That takes you to court?
And Marble Towers.
These are the lawyers that from
Yes,
time-
these are plaintiff attorneys.
Plaintiff lawyers?
Yeah, plaintief attorneys.
Okay.
Yeah. So we share the building with them. I arrived there, the first thing I'm meeting regions. The first region I met was Pretoria. We looked at the building, not too bad. We owned the building. It's in Manley. Then we go to this Marble Towers for the first time. And this is what the union says to me. We have been in this building, we want to get out. This is not a living. Then I look at it, and they are right. You must look at head office and look at Marble Towers. Chalk and cheese. You are sitting in your ivory towers there. You bring us here. We are not even safe and all that. And then, of course, there was a occupational health and safety that said this building is not good. We went in, we looked at it, and of course, the idea was that let's move. So I asked when I leave that meeting, what must happen? Can we move these people out? I committed to them that I'm going to move you out of this building. So I asked them, how far are you? They said, no, the process is quite advanced and all that. I said, give me a report. The report comes to my office. Apparently, my office looks at it, they ask questions, and then someone withdraws the report, right, because of the questions that are asked. At that time, Chair, we were also dealing with the head office building. And there were certain things that were happening in the list. For instance, in the head office building, one of the minimum requirements was 30,000 liters of capacity of water. How? Does Tshwane have a water problem? No. Why was this part of the requirements? No one could explain. What had happened was that even the building we are in now, which we decided to recommend to the board to extend, they were moving out of because it did not have water. And we were supposed to pay TI and all that. I think it was 120 million worth of cost. And the idea was that, let's do it. So we look at these things. We see it, okay. There's funny things that are put in the requirements and all that. And our idea was that, no. We're staying in this building. There we do. Then we go back. We meet with the... I look at the they had gone to the market, I think 6 times, and they could not get a building on Johannesburg. So I go and I meet with the National Treasury. They had said to them somewhere in 2018, please go and look at government buildings. And remember, I worked at PRASA, so I knew that they are government buildings. So I went, I think we approached PRASA, Transnet, and I said, go to PIC as well. So we approached PIC. PIC says we don't manage our buildings. PRASA says, no, you're going to have to help us. I don't know which building it was, but they were saying that we must actually help them renovate and do it. And I said, no, that's not what we can do. And I think Transnet did not have a requirement. And PIC then said to us, the people that manage our buildings is Moana Properties. That's where Moana comes. So we go to Moana Properties, okay, PIC buildings, they manage them. Remember, the owner is GPF. If you look at our lease, we've signed it with GPF. We go there, they've got 3 buildings, right? Got 3 buildings, we choose a team, we say go and look at those buildings. They're government buildings. They check them. Then they like this one. It's a former BP building. There was not a lot to do on it for people to move in. And remember, I promised people we were going to move you. So we do that. They tell us the TI, and we sign. We recommend the list to be signed by the board. The board signs it. We even explain this is a process. Lucky enough, Chair, sometimes fate works in its own way. We still had to get the approval of the National Treasury. For us, no, these days you don't, but then you had to go to the office of the Chief Procurement Officer, CPO, and ask for approval. They looked at it, we presented, they approved. We then agreed, the board had approved it on condition that the National Treasury does that, and then we went into the building. Moana as a state-owned. By the way, Moana is 100% owned by Pareto, who's 100% owned by GPF. Those who know will tell you that GPF owns that. They can explain, and no one is calling them. No one is asking Pareto, is he right, is he wrong? They're starting with stories. But this is a GPF building, Chair. We went in, yes, it was even cheaper than the previous building. And the costs are there, they were calculated. And then they come to me, I look at them, I agree, I sign, it goes to the board looks at it, we present, and the board agrees, and then that's how we got into that building. Now, is there capture at RAF? Yes, a lot of it. A lot of capture. And those that don't want to care, or some of us that refuse to be captured, will be called names. We're invited to all sort of manner of things, Chair. We refuse in the space of what we do. Are people capture? Yes, there are people that capture spaces. And RAF, Chair, it's a 48 billion economy. You must understand it. And if you want to understand it, you must understand it in the context of your PRASA. Probably their budget is at 25 billion now, or 30 billion. Ours is 48. Sanral, I think they're sitting at 33. I don't know what SAA is, should be lower. AXA is even lower than us. I think it's less than 10 billion, 10. But there's a difference about RAF. This is cash. There you have got to build a road, people must see it, and then you must spend. No, this is cash. People make money just by filling forms. Okay? And then you disperse this cash. And you must understand it as that economy. Fundamentally, you could sit there, Chair, and exchange a few things and make, let's just say the claimant gets 10 million, you can get 2.5 million easily like that, because people just take 25% of whatever the amount. And I'm even told that these days they want to claim that disbursements that are to, if they had hired a senior counsel, does not form part of that. You must call the legal services ombud to come. He must explain to you the difficulties of our people coming out of there. So, the more time you take in settling a claim, the more money the lawyer makes. It's a fact. Factual. So, that's why you would see, we say, give us the information. RAF Form 1, give us all the information so we can settle your claim. They take us to court. We say, chaps, medical aids, no man, you can't do that. There is this Medical Schemes Act that says whatever, court. We say, let's bring the medical tariffs, court. Anything we have done at the RAF is taken to court. And they said to me, well, we don't have to pay legal fees. We are lawyers. We just draft the papers and you see. So we want to change the model, court, Mabunda versus others. We'll get to it, Chair, because that 4 billion, you'll see how people want to play it. This so-called, they went and terminated an internal legal whatever that was assisting them. You must read the judgment of Ketsekele versus the RAF. It will give you a story about that. In fact, it says that the panel or the funds the legal representative were complicit in the scheme to fleece the RAF. It's not me. It's there in court papers, but you will see it. So who wants to capture the RAF? The people that continue to chow in the RAF. So, Chair, this 30 billion, we took it from the likes of De Broglie, the likes of Gertnel and Associates, and every other top-level law firms. And that's a fact. Okay, so when they fight, you are not surprised. They pride themselves by fighting. By the way, they killed RAPs, and they pride themselves with that. Now, Honorable Shikombane says, is there corruption within RAP? Yeah, well, one of my predecessors and one of my mentors once said to me, you can never finish corruption unless you are part of it. So as you move, it moves. So you must understand that as you move here, it moves the other direction, okay? So we never knew that the Discovery was claiming from us. Because how do you know? They never claim from us. They get their members and they hire a law firm. The law firm takes their members and they claim from RAF. And then at the back of it, they then say, let's pay us because you can't get this money, we have already paid it. So that's the reality. How we got it? There's a lady that came to me crying, I got money, Discovery is taking it. And I said, what do you mean? She says, no, they are taking it. They're saying it's our money. My lawyer gave my money to Discovery. Yeah, they are claiming. You went to Discovery. What does that even mean? So we went and we looked. And that's how we discovered this 500 million a year. Okay? Okay? So it will come back, Chair. And the deputy chair must answer this. The deputy chair of our board must answer this. Whether she was not at 360 Health, and whether 360 Health does not manage Sizwe Medical Aid, and whether Sizwe Medical Aid has ever claimed from RAF, even during the time she's on this board.
Repeat that. For record.
Let's start here. Our deputy chair once applied for a position as CEO of RAF and she didn't get it. Okay? She gets appointed to the board, right? After complaining about not getting the position. Then she's on the board. But when she's on the board, she is a CEO of a company called 360 Health, which is a medical scheme management company like Discovery Health. Okay? They manage Sizwe Medical Scheme. Sizwe Medical Scheme has been claiming from RAF during that period. And you can understand the fight between us and Discovery and whether what position she will sit in when it comes to that. But we'll get to that. Now, the issue around Honorable Shkwambani says issues of governance. I must say, Chair, when I was sitting at home, I was shocked when I was told no. Actually, the first thing that shocked me was a letter that says you have been placed on special leave. And I phoned board members, I was like, what's going on? And they say, what? We are not aware. So they check the letter. The letter gets sent to me before it gets sent to them. They then say, but this is not our decision. Until today, there's never been a serious board meeting that discusses that. Now, the issue about the CEO position is a very strange phenomenon because, as I said, we sat in a meeting where the issue around reappointment was mentioned. It was not mentioned by us. We can give you, if you look at my papers, actually it's in there. That indicates very clearly what must happen when reappointment is being done. Is there interference from the ministry? Absolutely. Absolutely. So the main person, the minister, I don't know about the minister, I don't remember her, but I know that the deputy minister has got a very serious interest about this because I do not think that she wrote to other entities and asked them the same and that they must advertise positions.
You see he?
There?
He.
Yes. The deputy minister.
I'm saying, you are saying she, he.
Oh, he. Oh, yes. I don't think he did that. Because, firstly, the RAF board, every time they receive a letter from the ministry, they panic. And then they ask for a legal opinion. even in this instance where they received that, they asked for a legal opinion. There was a meeting that was held, apparently instructing this, and they asked for a legal opinion. They must give you that legal opinion. And then from there, I would not know exactly what happened, but what I know is that on the 14th of May was the last day on our 360. People did 360. They must give you the outcome of that 360, because I don't think that it was paid using state money, so I'm sure you deserve to know. My view is that it didn't come as the way they thought, because in the 360 chair, LSSA was there to assess me, lawyers. I think BLA was there to assess me. The medical fraternity was there to assess me. I'm telling you about people. When I say 50 billion went, these are the people that are included in the 50 billion that we took away. So you must understand it in that context. I just said, let it be done. My rights are known. I will defend them if there's a need. So then there is an issue around security. I think, look, who wants to kill you? Hey, I don't know, I've got so many enemies. And most of them as a consequence of RAF. My children are protected. And against that issue of bringing assets back, I have refused to bring the assets back, because I still want those protectors to use those cars to make sure that my children are safe. But my children did not apply for a position at RAF. So there was that assessment that was done that my children must also be protected. Right? So we had to do a lot of other things. But there was a time when armed people, armed assassins, full in an H1, broke through, held people at RAF. There's security at the gate and then went in. Lucky enough that day we had a board meeting, ended late, but it was online. So I think they got their wires mixed that they would still be there, because we are people that actually work after hours. So that happened. And then there was a time when I had to be evacuated from a stadium because there was a hit on me. And we picked up that the heat was coming from the taxi industry. That I've discussed with the state security agency. So yes, they know about that. So there are cases as well that are opened there, Chair. So that's the truth. Now,
are you concluding?
No, I'm coming to Honorable Governor.
Okay.
Misconduct allegation, 79 million. I think I've dealt with that 79 million, Dean. Are you cleaning up the entity? Of course. It's very strange. These days, the so-called whistleblowers are everyone else that we have either fired, had problems with us when we arrived. These people that had mixed allocations and all that, suddenly these people are the best. They are whistleblowers. They are coming back. And then people tell them right so that we can act on it. We know. They meet with them, they tell them that. And we know that we have got evidence to that effect. In fact, I know those people by name, right? Now, the letter received, I wrote, I said, Honorable Member, that I received my letter on the 27th. Actually, I received it because I read it on the 28th in the morning. Before then, I did not know that I was on special leave. That's why I was somewhere here. It was, like I said, it was a shock. On the 30th of May, I write to them, and what I say to them is that your conduct is unlawful. I can't be there. Because I went and checked our leave policy. I signed that leave policy, I know it. I don't remember at any point where you can be given special leave without asking for it. And when they were confronted with that in this very room, they then started saying things. There's a lot of things. And I'm like, hey man, it was not SIU anymore. No, he didn't want to come here. Then when, as they do, every time someone wants to answer, especially the acting CEO, when he said, no, we have never been instructed to not come to Scope at all. It was their decision. I'm telling you, Chair, until today, as I know it, unless it changed after I was then put on suspension, the 20th of May decision not to go to Scopa has never been changed. Can't answer that. It has never been rescinded. So the decision not to come to Scopa is a board decision. You would see it in the letter of the 22nd of May to Scopa to say we are not coming. For that reason, please postpone. So the story that I said I'm not coming is not true as well to Scopa. Look at the last letter that we sent, I think around 4:25 on the 27th. It says, can you please postpone? So this story that I was not coming to Scopa is not true. Then when we realized that they're not going to move the meeting, they're not going to postpone, guys, there's an instruction from the board, let's all go. Then I land here, and then I'm told that I can't come here. She signs this special leave thing at 5:30. You see? Conveniently, it's not sent to me. I'm leaving at 9. It's only get to me at 10 to 11 when they know I'm airborne. There's nothing I can do about it. So those are the facts. Then I write to them again on the 31st, because I then realized something. They didn't lie to board members and say they could not find me from the 24th to the 25th on a weekend. I had gone AWOL. Firstly, Chair, 24th and 25th of May were a weekend. RAF does not open during weekends, and I don't think that I must ask for leave. I could have been anyway. But it's also not true. When you go and look at it, I've written it. It's in my papers as well. 36 minutes I spoke to the company, it's not company, board secretariat. I spoke to him on the phone. And you won't see any missed call because they lied. They just went and lied. Or misrepresented, as the chair would like to have it. But I mean, if you say, I can't find someone, I've got a PA, they never called my PA. I've got an office manager, they never called those people. Neither have they ever called me and got a missed call. So I've proved that, I've put that in there. Which office have you told? I went back to the chair and I said, if you are saying I must bring back assets, this includes vehicles. No, this includes vehicles. Those vehicles, one of them is an armored vehicle. A couple of them are actually armored vehicles. For obvious reasons, that the hit that was taken on me was never going to be with the 9mm. It was going to be a serious thing. So the idea of getting me an armored vehicle, now I must take it back. And I said, no, I can't. And then their lawyers came back and said, bring back the car. And that's what also made us to rush to court. Because the view was that, no, let's also challenge that. So we are saying that, what are we challenging? We are challenging the suspension and its subsequent instructions and conditions. So that's what we are challenging, Chair. It's a matter of public knowledge. It's there on the papers. The papers, apparently, they are doing rounds in social media, so they are there. Honorable Maduna, the building, I've said it. The BAC comes to me. I don't rubber stamp anything. I would never do that. Because then it's my issue. So I went, and it belongs to the GPF. The issue of the accounting standards, it's a board decision. Processed properly. We even have a review coming from PwC that says, no, you are right. In fact, the ASB agreed with us and guided us through this process. No one calls the ASB and say, why did you change your mind? We have said this to Scopa so many times. But of course, when you do that, you are just shouted down. No one is willing to listen. No, you can't say that. We hear you. We get that as a problem. Every time we come in this very committee room, actually, for all our sins. We are always shouted down. The ASB agreed. Even the accountant general agreed. What is not coming out is that we received a letter saying, do not go to the Constitutional Court. Please do the following. That letter we answered. We went back, Chair, to the ASB, to National Treasury, to AG, furthermore, to the International Accounting Standards Board that owns
Just without disrupting?
Yes.
Who wrote you the letter that do ABC?
It comes from the minister. That letter that says, don't go to court, apply this standard that is approved by the following. We said, Minister, we will come back to you. Let's go back to those people. Because the things you are saying, one of the things she's saying in there is that the accounting policy is in a policy space and it belongs to her. And we wrote to the National Treasury to ask whether in the PFMA or anywhere, where does she get all those powers? And the letter is there. It's written. It says, no, she doesn't have those powers. Those powers belong to management. It's there. There's a letter from the ASB. There's a letter from the AG, very clearly saying we don't deal with matters of accounting policy. And then, of course, we wrote to the International Accounting Standards Board to say, tell us about whether what they want us to go back to, which is if IFRS 4 still exists. They said it doesn't. And then we went to the International Public Sector Accounting Standards Board, whether IPSAS 42 still applies. They said yes, but you must still go back to ASB. All those things are there. When was that done? This year, before we finalized our financials. This issue that we don't listen, we are all that is not true. And I'll tell you, Chair, every time the board writes to the ministry and answers, they hit us with letters, there's a special meeting, we go around, we respond, then they go quiet. Then they write again. So that is what happens all the time. So the issue of the acting chief claims officer, was the board aware? Absolutely. Absolutely. In fact, they must give you my assessment of the previous board and this chairperson and the previous chairperson. You must see it in the assessment. One of the things that I am given more marks for is taking that as something that I must do. It is one of the reasons of my performance being at that level. So,
come again. So you are saying you have been rewarded?
Yes, for holding 2 positions in my bonus. So this story.
Did you hear the position of the board in relation to that matter?
It's a misrepresentation, Chair. I'm saying go back and check. Go and check. Go and check. It's a misrepresentation. It's a misrepresentation of the highest order. Let me tell you what was happening, Chair. We had problems in various regions. And we had gone to the market twice. This story that says, no, this thing needs someone who's medical and someone who is medical and what and law. It's not true. It's not true. In fact, the rationale of why we can't get people is that RAF, it's unique in the way that it sits. Okay? It has got an element of insurance, it has got an element of social benefit, it has got an element, but generally it's a social benefit scheme that is based on delict. Part 2 are saying it. You need to sue the state to get your money. Where have you ever seen that? But it's in RAF. So this story that it needs medical. By the way, my predecessor was a medical doctor. We still sat with 10.6 billion worth of legal fees. We sat with the highest medical bill. We were paying 5 times what medical aids are paying for the same procedures. He was a doctor. So this story There's no truth to it. So we'll get to that, Chair. But the reality is that they knew and they were aware. And I told them my decision and they agreed with it. What we then had was that we were supposed to fill the position, but then we went 2 times and we could not get the right people. We even said, let's try to develop our own team by internet, because we couldn't get people that understood the RAF Act out there and understood what RAF claims are made of in the market. Now, default judgments and state attorneys. Our state attorneys are very competent. Very competent. In fact, sometimes they give senior counsels bloody noses in these engagements. They're there. We can give the list of cases where they've won against senior counsel on matters of RAF. So this thing of now creating a couple of things happen, by the way. Not that they did not happen when we had a panel, where someone just goes there and then freezes or decides not to defend the matter or does not read the papers or whatever, because sometimes they've got more work or whatever. It happens in any organization. So we can't say simply because there is an incident there, we throw out the baby with the bathwater. That's not true. Okay, so very competent people, very good at what they do, and they've saved us a lot of money. As we say, 30 billion. That's a lot of money. Now, let's go to default judgments, because you see, there is a story that suggests the following, that if you defend a matter, it falls off the court roll. Absolute nonsense. There's no such a thing. When someone defends a matter, it goes on the defended part. There is the one that is unopposed court roll. Once you oppose it, it goes to the opposed court roll. It does not get off. And by the way, when that happens, it must go to trial. You can't allocate 10 matters a day that are opposed. It's not possible. Okay? So this story, you know, and it starts the very same way. By the way, when this engagements between the 2 deputy ministers started, it started this way, Chair. We were blamed for the court roll. We were blamed. People said, yeah, you are responsible for this court roll to be like that. Of course, numbers lemma lie. We went to them. We said, let's go back. This year, these are the number of things. Here are settlements. I think part 2 was showing you our settlements have increased over the period. We started showing those things to also to show that not you go to the work that was done by Professor Henny Klopper on the number of matters that were on the court roll. You look at what is now on the court roll on these matters, you realize that there's no truth to that. Then it changed. So every time we answer, we are attacked. Every time we answer, it mutates. This issue of the of what we are seeing now, which was being challenged, by the way, the law firms, including Gerrit Nels for law firm that ran to the Constitutional Court fighting about the new directive in North Gauteng that says mediation will be compulsory. Done by these guys of mine that also are said, you know, no, these guys are incompetent. We started that work long ago. And of course, in the process, the legal fraternity is also part of it and all that. We discussed these matters. And of course, I mean, I think that the judiciary got to a point where it's just unpalatable that they must sit and negotiate forever with people that are never going to agree with this negotiation. And of course, they went to court and all that. And it is going to come to court. Because anything you do to change this system, you are going to be taken to court. There's no question about it. The aim is to do what? Delay you. No, we need time. Hey, let's consult. Hey, let's do that. Because they do not want a situation where one day they find themselves outside. Every time you ask them a question, you must ask them, what percentage of your work as a law firm is RAF? They must tell you. Now, 4 billion, there's no 4 billion there. Nothing. We don't know, by the way, how they calculate the 4 billion, because we have never seen this so-called interim report. No. They come here, they tell you, no, the interim report is not used. Did you see what the deputy minister said here? So the deputy, an interim report can be used. Very strange. When we are told by the very same SIU that it can't be used. And I want to read you one of the responses that is also sitting in front of SCOP. Very interesting that when it comes to that, they don't tell you this, because I think it's important that we look at everything, including that response. This response, Chair, talks about, it's when the board is now saying, come and brief us on this matter, Chair. And they say, I'm going to try and get it here, Chair, because I think, okay. I'm going to try to get it, response letter of the 3rd of May by the SIU to the chair of the board. Paragraph, I'll make it available to you.
Yeah, I think you must make it, must make it available. Yeah.
Paragraph 11 says the investigation is currently at an advanced stage, including the process to grant affected parties the right of reply. Then it says, based on further consideration of the current stage of the investigation. Now they have now went and reconsidered it. This is on the, I think that the date is the 23rd of May. They then say, based on further consideration of the stage of the investigation, we are of the view that presenting the RAF board before the right to reply process is finalized would not be prudent. It's them that say this. The next paragraph, which is 12, says we will consider the request to present to the RAF board after the completion of the investigation process, including the right of reply process to affected parties. Then the DM comes here and says we can use this report. Because yesterday, Chair, I get it that people were asked, why didn't you put the SIU as part of his charges? And the others were saying, no, we should have. Others said, no, we gave you the opportunity to actually charge this guy. Now this thing can't stick. That's what was being said in yesterday's meeting. I think people must be honest. Now, Honorable Malamach, so I think I've dealt with the issue of the 4 billion. It doesn't exist because in any event, when you deal with the default judgments, if it's default and we see this person is given 10 million, in our view, this person deserves 3 million, we rescind it. The same thing that happened here. There is an illegal immigrant that says the default says must be paid, we challenge it. If you check it, it says the rescission is dismissed, and we said, let's take it to the SCA because we are rescinding it. Because we look at it, we assess whether it makes sense. If it makes sense, it's 3 million and then it was supposed to be 3 million, what's the point of defending it? We don't have to defend it, we then pay it. So this money that people say as a loss, Chair, is a problem. Just as suppose, Chair, it was even the case. We saved 30 billion. If at all we lost 4 billion, that would have landed us with 26 saving. Still, it makes commercial sense, but it does not happen like that. There's no 4 billion that is being lost at the RAF for whatever reason. That's not true. And it will be proven in the numbers. I think there's number. And they don't challenge those numbers. Once you give them that, they then run away from that, then they start something else. Now, efforts to notify the authorities, I've already dealt with that. The relationship between the ministry and the entire board is a difficult one. As I told you, they are scared. They are scared of being dissolved. They are scared of their names being done like that. Others were even promised that, no, we are going to dissolve this board. And when we dissolve it, you must not be found on the other side. They are going to dissolve it, and once they dissolve it, apparently hire others back. And I don't know what will be the criteria, but the reality is that you must sit with these board members and ask each one of them what the experience have been in being on the RAF board, especially in the 7th administration. Now, good relationships, they are very important. But what happens when your parent is actually very quiet? Someone tries to take 5.1 billion of our money. No one says anything. Right. No one says anything. I think that I skipped, Chair, but I'll deal with it when I find out, because the issue of the discovery letter becomes an interesting phenomenon. I know the letter. Because we responded to the letter, Chair. It came to us.
How did it come to you? Because not directed to you.
There.
How did the letter come to you? Because is the very letter that is read by.
Yes. I know the contents of that letter. I remember that it was July last year.
How did you respond to it? The minister referred it to you.
Yes.
Okay.
To say there is this complaint. It was a lot of them. There is a full response that also the chair does after this. I think a letter was signed on the 9th of August. But I was on leave, Chair. I was in Europe, actually, at the time. And I could see this thing. Since the appointment of the minister, they were just getting letters and letters. And I took an unprecedented move to write, to say, Minister, wait, let's brief you on these matters. All these other people were writing. All sorts of men of them. Others rehashing these things, and you'll see it in my response. I can share even the response, Chair. Because I could see. Then we said, Minister, wait, let's brief you first. As I said, we have never had an opportunity to brief the minister or the deputy minister on these matters. Never. So that's the reality of it. And of course, Discovery was going to lie and say whatever. They said what they said. But in there, they said, Letsoalo cannot be allowed to continue in this fashion or something like that. And I said, by who? They don't say by who. Of course, we give them a bloody nose there at the North Gauteng, we win this case. Then others go quiet, you see, because they were waiting for that moment. They hoped we would lose. Then they were going to create this instability, as it were. We didn't. We won that case. Why is the RAF not acquiring land? Now, the RAF does not even want to own a teaspoon. We are sitting in attachments every day. You know what happens when people were called to Scopa here? As we landed here, people were in Scopa. The sheriff was busy there, taking assets that don't even belong to us. Leased assets, they were taking them. It shows you the coordination. How did they know we were here? All the executives were called here, forced to come here. They were here. And then in Pretoria, in our head offices, people were attaching assets of G-Fleet. The cars that are there belong to G-Fleet. They were attaching them. You can't believe it, but it's the truth. Okay? So you see this coordination. So this complaint about Sefotla Modiba, no, Chair, you are going to see. We have evidence of these things. By the way, it's under oath. I received this thing. I never left Joburg until they dropped the charges and all that. It's there. They are not going to tell you that they say, no, we wrote to the executive mayor about something that he must say when he was not there. Okay?
You're going to repeat that?
Executive mayor Tada Morero was not there when these issues around Sefutla were happening. And I'm saying we have got letters indicating very clearly that these charges were dropped. And they were dropped before he actually came there. The story that whilst he was busy being charged, he left is not true, Chair. So these ones want to ignore this thing. By the way, the chairperson of Scopa writes back to the lawyers of Mr. Mudiwa, and he's not saying these things. He says, yeah, there's a differing views and what will allow this process to proceed, and then someone gets suspended for it. Right? And it so happens. And then people are refusing to sign their own decision that they took to suspend someone, and they want to use someone as a stick, and they say, you must sign there. It's wrong, Chair. So, Mr. Lukwareni is under pressure. They want him gone. The sooner he leaves, the better. And all of us, apparently, that we are going to all follow suit and we are going to leave RAF, they are cleaning. That's what they said on the meetings of the 29th of, that was held in RAF offices by those three that I've already referred to. Now, I've taken you through the SIU matter. There's nothing as painful as someone coming and saying you have done something and you hear it for the first time on YouTube. You sit there and someone says, hey, they say you are responsible for something. Apparently, I've got even 2 ID numbers. So someone was making aspersions about me having 2 ID numbers and all that. I've never been cleared. What? Chair, my first job was at the South African Reserve Bank. You will never go there without being cleared first in the first place. So I worked for the state. When I left there, I went to Department of Public Enterprises. I left Department of Public Enterprises. I went to private sector. I came back, appointed by cabinet in 2008 as a DDG in the Department of Transport. And people say, no, they cast aspersions about my clearance. I'm clear. I'm clear about that. They tried some funny things 2 weeks back to say, refill your form. I said, tell me about the one I filled. Well, where did it go to? Because they wanted to come back and make it about, no, he has started now. No. The SSA must do its work. We are there. I mean, we are there, the clearance. And people must understand. I heard the story, Chair, that when you are cleared, RAF does not deal with secret matters. No. At best, confidential or strictly confidential. There's no top secret there, RAF. So the clearance, people must understand that clearances are also by category. So you can be cleared for, you can fail top secret and be allowed to go secret. You can go, it's miss. People must understand what clearance is about. And clearance is not about this. And then your issue, I think I've answered it, Chair.
Yeah, you did.
About the chief, the chief claims officer.
The claims officer.
Why did it take so long? As I said, we are trying to get someone we didn't get. And then lastly, what, Chair, I think your recollection is incorrect about interference. Honorable Malemaja said to the chairperson after she presented, said, are you a coward? Why don't you tell us someone is interfering? If you remember, go and listen to the tape. When after the chair had presented, you then said, who is this giving instructions? Is there someone interfering? You must be clear and tell us who's interfering, because very clearly there's interfering. Honorable Malemaja said that there in our head office. You must remember that meeting.
And what was the answer?
The answer? No, I mean, we laughed about it because she was keeping on telling you that we have been getting instructions and letters every day, she said. And you said, then it means someone is interfering. And then we just laughed about it. But
No,
the reality
I'm
is...
saying, did it come out in that meeting that there is this person who's interfering?
No, it came out, Chair, that there was someone writing us letters nearly on a daily basis. And Honorable Malemaja said, then there is interference, you must just call it for what it is. Go and listen to the tapes.
No, I agree.
Yes.
I'm saying you, the board, or in whatever that session, that matter was downplayed. It was never elevated clear that there is interference. Are we agreeing on that?
Yeah, Chair. Remember, some of us are not direct, others are direct. But the fact remains is that it was mentioned that letters are written nearly on a daily basis.
Yeah.
We are fielding instructions after instructions. And that's the truth. And I'm saying, go and look at the pattern, Chair. Look at the number of special meetings and look at the number of letters that have been written to us and what those letters were saying.
Okay.
Yeah. what broke the camel's back? Well, people are scared. Others we have bills, Che. We have bills, right? Most of us, we are black, we have bills. It's not nice to be told you are not going to get money, that your children are going to starve. We are going to either dissolve you tomorrow or whatever. So people are scared. And if they are scared, you are going to see that serious instability. Others will stick it, others won't. But Chair, it will be a travesty when some of these board members that work so hard, that have defended this thing so hard, are now thrown out. It's like throwing the baby with the bathwater, simply because they are under duress. There has been duress there, and you must ask about it. Because it's only clear, and you're going to see it, that this organization is not stable. But it's just a whirlwind. It is happening now, and then some people must be put aside, and then some will come in and do whatever. The reality is this: it is not easy to be a rough executive. It's worse when you are at the board. Because remember, some of the times you are not in the organization, so you wouldn't know. People will write to you and do whatever. Others will meet you in the corners. Others will send you stuff and all that. And they will tell you, hey, these things are going wrong. Then you go and you check. No, there's nothing here. And when you do, they say, that one, they are controlled by that CEO. There's no such a thing, Chair. So I'm saying to you, Chair, that's the issue. So the issue of non-payment, Chair, you must help us. SARS has acted recalcitrant. In fact, we have opened a case of contempt of court against them. And we are sitting with the Minister of Finance was supposed to submit to court on an urgent basis. And I think since April, he was supposed to have submitted a certain affidavit. He has not done it. So that they keep on deducting the money. Then you're going to come back and say, why didn't you pay? Because it's not there, Chair. SARS is unlawfully deducting our money. So, Chair, I hope that this portfolio committee will write to them and ask them. Because clearly the ministry has not helped us. So it's important, Chair, that when we look at those matters, you understand that 5.1 billion is a lot of money, Chair.
Hold it there.
Yeah.
So you went court with SARS?
Yes.
You won against SARS?
Yes.
But SARS still deduct?
They ignored the court order.
Have you went back to court?
Yes.
Okay.
In contempt. And then we said they're in contempt. And then they said, okay, let's clarify what must happen. And then they said to the Ministry of Finance, give them this order that they must give us an affidavit. And they didn't do it, Chair. They didn't do it. We are sitting here, they have deducted. I'm sure now they're sitting probably at close to about 5 billion of that money. So where do we get the money? Remember, we don't get an increase in the fuel levy. Right? Medical inflation goes up. Everything we are paying goes up. And we sit here and someone just in the middle of somewhere just decides that I'm going to deduct your 5.1 billion, which we are saying is unlawful. So we sit here with this board, by the way, this very board must sit and take those decisions. What must happen? Why are we not getting any support? And then you come and blame them, Chair. I think it would be unfair. Thanks.
Honorable members, it's still early. I can allow you another round. No, yeah. I must thank you for, one, having, under the difficult circumstances, allowed you to come here and widen our ears and widen our eyes. I must say it here on record, colleagues, friends, compatriots, that I'm more convinced than any time ever before that it was necessary to call the CEO here. And I feel sorry for those members who left and could not get. I hope they'll be able to get through other channels. Because it's very dangerous to make a determination based on one-sided story, which I've seen as an attempt by other members to do it. Then I must reiterate, I was very clear in my conscience when I needed a legal opinion on this particular matter, because I knew that members, when they serve certain political agendas and certain political interests, have a tendency of somersaulting. And I needed to be legal wise, and that's why I did what I did. And I'm really very happy that we're able to achieve through that particular process. And I must thank you all honorable members, especially those that proposed that we must have him here to give the account. Also that you did not tell us about sub judice, because I think maybe it's because you are confident of what you are talking about. So we really appreciate that. Our eyes are more widened than any time ever before. We know now that when we came to RAF, by the way, we did not know to this extent. Now we know even deeper now. And we're very, very happy. It will assist us as we continue to navigate and propagate this particular space, to know what we really deal with. We're never going to be tempted at any point, as others were trying to do to this committee, that we must meet with SCOPA before we meet with all these all these parties or role players. Because we can't be an oversight body that want to listen to a standing committee on the matter, to be briefed by a standing committee. Not the committee that I chair. It will never happen. That, forget it. It will never happen that I get a briefing from another committee on the responsibilities that I must get briefings directly. I'm saying this on record, including to all those members who had left on that particular guise. It's not going to happen. It will never happen. And I want to appreciate all of you who stood here and remained here, that for your servanthood and in the interest of the people of the Republic, because these are matters that have to do with the interest of the people of the Republic. To the extent that you're able to sit here until this hour, to dig deep through him, to understand through him what he knows that we ought to know. In your part, Mr. Lutswalo, I'm going to request that some of the information that you have mentioned, I don't know whether you may want us to write you the issues, the things that we want, or some of the information that you think you must voluntarily favor us with. It will go a long way for us to continue to study and understand broadly what is currently happening, including a list of all these law firms that are benefiting and how much over what a particular period, including those that it is only 2 companies that were mentioned that were major beneficiaries. But it's not what we are saying now. So we want all the list of the beneficiaries. We'll never be blindfolded in terms of accessing information. That's not going to happen, not in our lifetime, not when we're here. I want to close this meeting. Colleagues, you want to assist the chair in summarizing?
Chair, there's a very serious issue of Mr. Lutswalo's security that he spoke about. That he no longer has security. Can the chair comment about that? I'm not sure how you would comment on that one, Chair.
Honorable Kubega, if you heard well, that's the matter that has been ventilated at this point in court as part of the sub-issues of suspension. Is that so, Mr. Lutswalo?
Yes, Chair, I must make it clear. I'm saying when I came here, my security was refused to travel with me. But so far as back home, where I'm going, they are still there, but they can't travel with me for obvious reasons, and they are taking away the assets they must use to accompany me. So it must be seen that it must be clear.
Do you still have bodyguards?
I still do have them, but I left them at the airport. I came here alone.
Okay.
Yeah.
I think let's note that, and then we'll see how to deal with that as we move forward. But thanks very much, and I think the meeting stand adjourned at this hour. Thanks very much.